My lord, item 48. Item 48.
14.
48.
Yes.
On behalf of Senior Counsel S.K. Talukdar, Cooperative Department, with the consent of the other
Item number?
48. 48.
It's 48.
On
Yes.
behalf of Senior Counsel S.K. Talukdar, with the consent of other side, I beg to mention for an adjournment for a week, as Senior Counsel has undergone an eye surgery.
SK Talukdar.
Yes, cooperative,
48. 48. No SK Talukdar is there.
cooperative department.
So for the corporation department.
Yeah.
Why the matter has come up?
My lord,
Why the matter has come up?
my lord, I am just instructed to seek
No, no.
for the adjournment.
If you don't know, don't mention. Next.
I have no objection, my lord. Item 48, I have no objection.
Why the matter has come up? There's an office note. We'll see when the matter comes. Next.
What you would like to mention item number 63. Can it be taken up at court at any time before writing your lordship? Actually, this IA has been filed for clearing a defect in the order. The petition has already been disposed of, but there is a clerical error which needs to be.
By this court?
Not by this court, by just Honorable Mr. Justice S. Sheikh.
Yes.
So, Mr. Sheikh.
Let it matter be listed before him, na? Item number 63. Taking into account that the order which is sought to be corrected is an order passed by Honorable Mr. Justice S. Sheikh. Let the matter be listed before the appropriate.
Take it by the lordship practice, otherwise they are not getting the benefits of the order.
What is the mistake?
Mistake was that your lordship, they were seeking appointment in terms of WA 145/2017, master role workers, minimum pay scale. So initially the department took a stand that only the those who are appointed prior to FRBM period, they will be granted. Post FRBM will not be granted. But subsequently by way of a notification, it has been found that even the post FRBM has also been granted. Now while holding this, your lordship, the court has said that pursuant to that notification, only prior those who are appointed prior to FRPM, they will be considered. But in fact, prior to FRPM as well, post FRPM, both will be considered now. Ultimately, the direction was given that we should be considered in terms of so and so. But while holding in the middle of the order, by mistake or by clerical error, prior to as well as post FRPM, both are now entitled.
So what is the urgency?
Otherwise, if they go, they may not be considered.
There will be. You mentioned it before the registry. The registry will list it.
I am deeply obliged.
Next.
My lord, I beg to Mr. I don't know 56. The contempt matter, my lord, an order called by lordship is already applied. We have received the payment.
Mr. R.M. Dekha, the learned counsel appearing on behalf of the petitioner, submits that the order for which the instant contempt proceedings was initiated have been duly complied with, for which he would not like to further proceed with the said contempt proceeding. Taking into account the above submission, the instant contempt proceeding drawn against the respondent stands dropped.
For item number 69, the conducting counsel is
60.
the conducting counsel is having some medical emergency of his side. Kindly explain the matter for today. The other side has been.
Who?
History department, newly engaged. In other ways,
No. This was a simple thing which was to be asked as to whether your person is still willing to go ahead with the tender. Because of the fact that this was done in the year 2019. That is the only instruction which I have asked for. What is there? And whether you are still going to go ahead with the tender.
Lordship, I have just newly engaged in a standing order.
Fantastic. Ask them.
Lordship,
When the matter is reached.
The counsel has informed his daughter is being injured in the hospital.
Understood, but just find out that thing and you find out that thing. This matter was taken up the day before yesterday and I fixed the matter today because of that, only that instruction. As to whether,
Lord, actually, I am not aware of it.
if you are not aware, don't mention the matter. You find out. Because there was a stay. This was a case of fish feeds. if there is a stay to the fees fee, the amount which was to be paid, a tender, he may not be agreeable now to get it at 4, because 4 years have
Yes,
passed
Lord,
by.
yes.
And whether you are still willing to go ahead with the same tender, because 4 years have already passed by.
Okay.
You may like to go ahead with a fresh tender.
Yes, Lord.
That's the only instruction.
Lord, yeah, can it be at 3, Lord? Otherwise, it will not come.
Huh?
It is in the last part.
It would be. You just make the mention when the matter. Yes. No adjournment.
And number 67 for withdrawal.
Yes. Your name?
My lord.
Your name?
Yes, Ambe.
Okay. You want to withdraw?
Yes, my lord. With a lever.
The learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal.
Liberty may be.
What liberty? Liberty what? Liberty for what? Don't come up with a liberty unnecessarily.
Only liberty may be.
Yes, Mr. Barbuzari. He's asking for liberty. What is this matter about liberty? Why you are asking for liberty?
Ex gratia benefit, my lord.
Huh?
Ex gratia benefit.
Ex gratia benefit. Now, why are you asking for with liberty now? If you are withdrawing it, why you are asking for liberty?
My lord, actually, in this case, representation are given, but it is only we stated in this writ petition, but we are not an act. We are filed a fresh with annexing that.
You want to bring on record the representation?
Yes.
Then file an additional affidavit. Why you are withdrawing it?
Another, sir, my lord, district is wrongly Nolbari mentioned, but in the title page, but it is Baksha.
So what?
So
That has no relevance. Boxer, wherever it is, you are asking for instruction, you are asking for this particular amount.
I am praying before this honorable court to do this and file a play.
If he chooses to withdraw, let him withdraw. If he chooses to withdraw, let him withdraw.
He once again at liberty. Now, learned counsel appearing on behalf of the petitioner submits that on account of certain formal defects, he wants to withdraw the instant writ petition with a liberty file afresh, taking into account the said submission and the same not being opposed by Mr. R. Barbuzari, the learned counsel appearing on behalf of the Revenue Department. The instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to file afresh by removing the formal defects.
It is that kind of petition, my lord, where the issue is, my lord, flood drowning. So chief has directed in an earlier matter the department to file an affidavit to clarify the matter. We have already sought for instructions.
Yeah, I've seen that. That is the flood. They want to withdraw
Yes.
and help it.
Item number 1 for motion.
Yes, what is this?
May it please your lordship. My lord, this petition is filed against challenging an order, impugned order, that is at page 45, my lord. It was passed by the respondent number 5, directing that I was working as a constable, my lord, operator, a PRO, my lord. And after my retirement, while I submit the pension papers, my lord, then one of the admit card was found to be fraud, my lord. Found to be one of the admit card of SSLC. At the inquiry, they found it is a fake admit card. Therefore, the respondent number 5 passed an order that the entire salary you have get in your tenure should be recovered. So
That's why, we are asked to SEBA asked to verify all these things. Accordingly, I am appearing on behalf of the SEBA, though we are not party, as per direction of the Honorable Court. Lordship, kindly see page 23 to 23 to my lord 27. These are duplicate certificates. These are genuine. In these certificates and admit cards, his age is 17 years, 10 months. This is correct. And page 34 is my lord. That is a fact. In Action 9, page 34, Sarikuddin Ahmed so and so. Rule is different, number is different, age is different. This is a fake one. That is that he is facing my lord departmental proceedings. Criminal proceeding also. But my instruction is this, my lord. I have gone through it. These are the not genuine. Only this duplicate certificate, admit card, those who were written in the age is 17 years, 10 months is correct. His age is 17 years, 10 months.
You have retired?
My lord, I have retired. I have retired on my lord.
Supposed to return 22.
2020.
And when did they start the departmental proceedings?
My lord, departmental proceeding has not been initiated because already I have been retired. So
Then what, on what basis are they withholding your pension?
I don't know, my lord. I am
No, the petitioner is alleging in the writ petition that there is a criminal case pending. So
There's a criminal case
Yes,
pending.
yes,
Yes.
true.
When?
for
My
pendency
lord, it is a,
When was the criminal case initiated?
my lord, the FIR was filed on 18 June 2022 after the retirement.
FIR was filed on 18 to
18
2022.
6 2020. And I was retired on 30th of 4, 13th April 2020. After 2 months, this FIR was
Wait. You retired on
34 2022.
34 2022.
Right.
And FIR filed on
And FIR was filed on 18th of June 2020.
on the ground that you have given a fake certificate.
Fake one admit card. I have submitted one fake admit card.
Now, what about your age?
My lord, my age is as per the original documents, original admit card of SSLC. And 31st of March 1980, my age was 17 years, 10 months. And as per the fake admit card, it was 15 years, 10 months.
Why?
My lord,
Hmm.
kindly see
FIR
the,
Now you have not received your pension.
my lord, I am not ready.
FIR my lord will find at page 39 of the writ petition. Page 39. So there is a my lord increase in his age. Thereby he has remained in service for more than 2 years.
And what was recorded in your service book?
My lord, in my service book, it was recorded as per 31st of March 1980. My age was 17 years, 10 months. My lord, so far this fake admit card is concerned, it is true, my lord. Because, my lord, after joining in the post, my lord, I submitted my original documents. It was verified and I was appointed.
No. You submitted a fake document.
No, my lord. Subsequently, it was filed. The actual fact is that, my lord, after getting the job, in the meantime, my lord, my house was, while I was shifting my home, then all the documents, my file was missing. Therefore, through a middleman, my lord, I obtained one SSLC admit card, my lord. And that person gave me that admit card, which is fake. I don't know whether it is fake or not. But while I submit at the time of retirement, my lord, and while they investigated the case and compare with the original documents in the file, then it is found that it is a fake admit card. Otherwise, my lord, kindly see at page, my lord, 23. Page 23, my lord. This is a admit card, my lord. Under roll B71, non 79, I appeared in the examination in 1980, my lord, and I was failed. I was not passed at this time, my lord. Thereafter, my lord, page 24. It is a mark sheet, my lord, under rule B71, non 79, and I was failed, my lord.
No.
The mark sheet,
If the fake certificate, if your certificate is fake,
Right.
then it would amount to overstay.
my lord, as per the certificate, fake certificate, I overstay for 1 month.
Only 1 month?
Not only there is discrepancy with regard to the two admit cards, In fact, his date of birth also does not tally with his PAN card details as well as Aadhaar card details. That my lord will find that page 41 of the writ petition. That is the forwarding report. The petitioner was arrested. Petitioner was arrested.
You have put him to arrest also, and you are now not paying the pension.
No, my lord will kindly
My
see here.
goodness.
The first paragraph, my lord, defects of the case down below, my lord, in that paragraph.
No, let us read from top. On
Yes.
19/6/2022 at 9 a.m., informant Chitaranjan Oja, son of so-and-so superintendent of police, and taking that one more subsequent facility working as sub-inspector in a by respect of the aged participation. So it is 2 years, not 1 month.
My lord, it is that page, kindly that page,
No, page
45.
41. Page 41.
the difference
It's 2
is
years. His SSLC compartmental certificate 81 hearing serial number was not issued by SEBA, not genuine identification.
एप्रिल 2022 एप्रिल 2022 का होता है त्या डेट ऑफ बर्थ 1963 स्टेटमेंट देखिए मिडिलमेन टेबल लिखते सर
I think the better of this is a case where notices to be issued. You file your affidavits.
मतलब my instruction में भी कैप्स
No. You file your affidavit, whatever you make. I'll look into it later on.
मतलब we should be made party my lord.
You are not party?
Not party.
Very well.
Request of the court, my lord.
You will have to file an interlocutory application for implementing SEBA. You will have to file an interlocutory application.
Issue notice making it returnable on. When can you file your affidavit? Who is to file the affidavit? Government?
Government, but call it.
Issue notice making it returnable by 18th of December 2023. The petitioner shall take steps upon the Mr. S.R. Borua appears on behalf of the respondent number 1, 3, 4, 5, 6, 8, and 8. Mr. R. Babudari appears on behalf of the respondent number 2 and 9.
My lord.
And whoever you
He refer for respondent number 7.
so appears for the respondent number 7. Taking into account that the respondents are duly represented, extra copies of the writ petition be served upon them by Tuesday. It is to be devoted to by 14/11/2023. The respondents shall file their affidavit on or before 14th of December 2023. It further transpires from the records that by an order dated 11/9/2023, this court directed the counsel appearing on behalf of SEBA to obtain instructions in the matter. Today, Mr. T.C. Sutia, the learned standing counsel for SEBA, have placed before this court certain instructions. The same are kept on record and marked with the letter X.
We need not file affidavit, my lord.
No, you are not a party now,
Not party now.
so I am not doing it.
Obliged, my lord.
Obliged.
Yes, what is this?
Lordship, I'm under suspension from last 21 months.
When were you suspended?
Lordship, 2/2/22.
2,
2/2/22.
and then
Then Lordship, no memorandum of charges served.
what
upon
is
me,
this?
No charge sheet, no extension.
Yes,
Your Lordship, if Your Lordship comes to page number 32, he intimated, I'm not sure about that particular date, if he was suspended on 2/2/22, he prayed for reinstatement on 25/1/2022.
Lordship, it is 25/11, that is a typo.
Hmm?
25/11/22, Lordship. It is a
25/11,
mistake. The SME is copy.
no, forget about that. When did you, where is the suspension order?
Lordship, it is at page number 29. It was a deemed
Deemed
suspension due
under
to arrest.
suspension
Lordship,
pending
subsequently
trial
it
of-
was confirmed.
So this was done on 22/3/2022. Why you are saying 22/2?
Lordship, it was deemed suspension from 2/2/22. Subsequently, it was confirmed.
You were arrested.
Lordship.
Are you still inside?
No, Lordship.
When did you get the bail?
Only 5 days I was inside.
When did you get the bail?
9/2.
When did you inform?
Lordship, the first petition I have furnished on 23/11/22
Which
person.
position?
to reinstate me into service.
Where is it?
Is it page 32, Lordship?
I was placed under suspension and subsequent to this is my humble prayer. But where have you informed that you have been reinstated? You are no longer in custody.
No, Lordship, this I have filed in person. I have filed this petition in person.
How do I know? You should have informed very well. You should have informed them that look here, I am out. This is my bail order.
Lordship, when after coming out from bail, when I tried to join the service, I was not allowed to join.
Have you informed why were you put under suspension? This was done under 6-2
Lordship,
because of the fact that you were in custody for more than 24 hours,
48 hours. Lordship.
for 48 hours. Now, after coming out, you must have informed them. You have to inform them. Then only the 90 days will come of Ajay Chaudhary. Where have you informed that you are no longer there?
Lordship, when I have filed 2 petitions for reinstatement. in
How do I know? You may have, somebody must have signed it out there, from inside. How do I know? Why didn't you inform that you are no longer in custody? That's the law. Has the law changed in the meantime, Mr. Barbujari?
No, but Ajay Kumar
Huh?
Chaudhary, Lordship, it doesn't say.
From the last time I was there sitting in this bench, the law still remains that.
That's the law.
So, you are to inform them. Unless you don't inform them, your 90 days doesn't start.
Lordship, in my respectful submission, Ajay Kumar Chaudhary does not say so that it has to be informed. Subsequently, this court took a view.
Is it the case of Ajay Chaudhary where it is stated in Ajay Chaudhary, kindly appreciate, is it the case of deemed suspension? No. That is why it was not stated.
Subsequently, Lordship, in Dekupiti MS, this division bench of this court holds so that the same principles will apply to suspension under 6-2 deemed suspension.
Absolutely. But then also there is another judgment passed by this court out
Yes,
there
sir.
where I made it very clear. I
Prasanta
forgot the
Datta.
name.
Prasanta Datta.
Prasanto-
No, not the person.
Rafid Ali.
Rafid Ali. Rafid Ali is fairly on this point, wherein I have specifically mentioned that apart from the 2-3 reasons which are given out there in 6-2, there is another one which is there to the effect that you have to inform that you are no longer in custody.
In rapidly, Lordship has called out the fourth exception.
Yes, the fourth exception. If you have not done it, how do I help it?
Lordship, 6-2 does not say so. That I have to inform that. It might be in Rafael.
Does 6-2 say that you have to, you will be out if the memorandum is not given within 90 days? Does it say? No.
Lordship,
Mr.
my case
Sara,
is- Lordship, my case.
kindly appreciate one thing. You were supposed to inform them.
Lordship, my piece-
You have
I will
not
take
informed them.
I will take instructions. I might have informed. Lordship.
Okay.
I will take it, but Lordship, in my respectful submission,
Hmm.
can, without any charge sheet, without any memorandum of charges, they keep me away for 21
If
months.
you are still inside,
Yes.
how do I know?
Lord-
Your right to be reinstated only arises when you are outside. Otherwise, if we go by simply by Ajay Chaudhary or Rakibuddin's judgment, you are inside just for example for 5 months. And on the third day of your 48 hours being completed, you were there. Can you be reinstated when you are inside? No.
Understood.
So under such circumstances, your right only accrues on the day when you are out and you inform that, look here, I am no longer in custody.
Lordship,
Then-
we will just have one view at page 21. At page 21.
Yes.
The only allegation against me I want to show to the court function. The only allegation which is against me as per the FIR. Lordship, it says specific incident that came to
Where
light.
is the other judgment? That there were two judgments. One is Ajay Chaudhary, the other one was
Prasanta Datta.
the other judgment which was there. Wherein they were dealing with section 10 and I distinguished it in another matter wherein I said that that judgment would not be applicable out here. What was the name?
Lordship, I will find out and I will come prepared next day. Lordship.
Don't come prepared out here. I have to issue notice here. I don't keep these matters pending in this manner.
Lordship, just instruction about the bail thing I will take.
No, you issue means in the meantime you inform or show me a document by which they duly admit that you were there or any notice has been issued to you.
Perhaps next day I will.
If this 90 days is there, then obviously this can be.
Next-
We'll issue notice. This
Lordship,
type of matters can keep
specific
done.
allegation against me, Lordship will have.
That is Rajiv Kumar. Rajiv Kumar.
Yes, Rajiv Kumar.
Rajiv Kumar.
Rajiv.
They say that
So the period of limitation will begin to run once he has informed his employer.
That I am no longer in
Yes.
custody.
There has
That's
to
all.
be fair information between the employee and the employer.
Once you inform, then only they can. Or are you going to, do you expect that the employer should be just waiting outside the jail and to serve you the memorandum? My goodness. Okay, heard Mr. D. Sir of the Learned Council, issue notice making it returnable on 18th of December 2023. Mr. Arbor Pujari appears on behalf of the respondent number one
One only my
and Mr. S.R. Borua. Oh, you are appearing? Yes. D. Bora appears on behalf of the respondent number two. As the respondents are duly represented, extra copies of the writ petition be served during the course of the day. The case of the petitioner herein is that the petitioner was arrested on the basis of an FIR filed being FIR number which was FIR
page 21.
on the basis of an FIR being registered and numbered as Kamrup CID case number 7/2021. The petitioner was arrested on 2/2/2022. Subsequent thereto, by an order dated
29.
22/3/2022, the petitioner was put under suspension in exercise of the powers under section 6(2), rule 6(2) of the Assam Service Discipline and Appeal Rules 1964. And it was also further mentioned that the suspension shall continue pending the suspension shall continue pending withdrawal of departmental proceedings. From the materials on record, it is not clear as to when the petitioner was released on bail.
Bail order is there on. Bail order is there on.
Huh?
Bail order is there on because it was not.
Where?
It is at page 26, sir.
It appears on records, from the records,
Page 28.
that the petitioner was released on bail on 8/2/2022 by the CGM Kamrup Metro.
Bond furnished on 9.
However, from the records, it is not clear as to whether the petitioner had duly intimated the respondent authorities that he is no longer in custody. It is the further case of the petitioner that the petitioner had represented before the respondent authorities for reinstating him in view of the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India reported in so-and-so, as well as the judgment of this court in the case of, what is that? No. Rafed Ali versus State of Assam reported in so-and-so. It is the specific case of the petitioner that the petitioner being no longer in custody and there being no and no charge sheet, oblique the memorandum of charge having been submitted, having been served upon the petitioner. The petitioner is entitled to be reinstated to his service. The respondent shall, on the next day, apprise this court as to whether the provisions of whether the judgment, the law laid down by the Supreme Court in the case of Ajay Kumar Chaudhary Supra, as well as by this court in the case of Rafed Ali Supra, and the office memorandum dated 4/2/2020 have been duly complied with. With this, you will get reinstated. Don't worry.
Applies.
Number 3.
Mr. Saraf, you submit a copy of this order to the to whom? To the district commissioner. The petitioner is further directed to serve a copy of the order to who has suspended you? The district commissioner Kamrup Metro. Yes, Mr. Mam.
My lord, the petitioner is a peaceful teacher
Hmm.
and he is working under Rupee Education Block in the district of Nagangwet.
Hmm.
And she is a resident of Tirisguri in the district of Hojai. From her house, her school is 120 kilometers, and that too after crossing 5 buses. She has to go every day. She starts from school at 6 a.m. and reaches at home at 9 or 9:30 p.m. In such a manner situation, my lord, I filed a petition before the district coordinator that lordship may kindly see page 26. Page 26.
Oh,
The district mission coordinator recommended my transfer to Hosai district. And that was followed by the consent of the headmaster, where I sought to be transferred. That lordship may kindly see page 23. On the other hand, my husband is totally physically handicapped. He needs 24 hours care and protection. So my prayer is this: the recommendation of district coordinator which he has made, page 26, that should be implemented.
So you are still at Nagaon?
Yeah.
You want to go to Hosai?
I want to go to Hosai because only 120 kilometers, 5 passes have to be crossed. I am a lady, 2 minor children, and my husband is also physically unable to move.
From
So this is
Nagaon to Hosai, you have to cross how many buses? 5.
No, my lord. I live at Oxford Pathar. From Oxford Pathar, I come to Muraja. From Muraja to Nilbagan. Nilbagan to this highway that is Link Road.
But are you properly appointed teacher?
Yes, that is there.
What?
That my appointment letter may be sent my lord pays.
That part is okay, Lord.
I have given the agreement. Kindly see that is in record. Last time it was sought for, and that has been fulfilled. Kindly see the agreement.
Now you are appointed as what?
As the assistant teacher.
As assistant teacher.
By
These are contractual.
Contractual lordship, subsequently decision was taken not to terminate them till the age of 60 years.
Yes.
So on that terms, they are continuing.
Okay. Now what is the transfer policy for them?
Lordship, in 2019, Lordship, government took a decision not to, keep in abeyance the transfer policy of any teacher, Lordship, till a final policy is formulated, Lordship. In 2020, Lordship, one policy was formulated, Lordship.
Where is that?
Lordship, it is not there in my instruction, it is my instruction. And one section 9 is there, Lordship. Now the process is online process.
Oh, that I know. That is the act.
Your Lordship is aware. Your
No,
Lordship has
he can
passed
apply
on.
as per the act.
Yes. No, now, Lordship, her application was in the year 2019. Now, after coming into effect of the new act, Lordship, she has to apply under section 9, Lordship. It is an online mode, Lordship. We will definitely consider, Lordship. If she is found eligible, Lordship, we will take a particular
time. Within a particular time, they may.
They will apply. You apply, they will consider.
Yes, Lordship.
That's all. That is under that new act,
Lordship.
education manual.
I don't know.
No, that education manual is there. It is there in the first 2 pages.
And my hardship, I kindly observe. 120 a lady teacher, and 6 a.m. I have to start from my school, and at 9 or 9:30 I come back to my house. At 6 a.m. I have to start for the school. 120 kilometers, they'll have to charge 5 buses. So all this may kindly be observed, so that
This was the Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer Act.
2020.
Now, whether that is applicable to the Sarva Shiksha also?
Yes, they apply. Yes, yeah. Section 9.
This is Section 9 is the power of Deputy Commissioner.
Yes, Lord.
We are not the concern here. This is will come under Section 7.
Section 7.
And he has to apply as per Section 3 or 4 somewhere.
No, here, Lordship, Section 9, Lordship.
This is in the case of exigency for maintenance of proper academic atmosphere in the school or the maintenance of peace and tranquility. The Deputy Commissioner, after observing such formality as may be prescribed, is satisfied that the transfer is essential for any one of the said grounds may refer to the competent authority. What are the grounds? A teacher may seek transfer only on the following grounds: safety and security of female teachers.
Lordship, that is the.
We dispose it of.
Lordship, I kindly peruse my instruction, Lordship. One paragraph.
The instant petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in not considering the request of the petitioner for transfer from Nagaon to
number
3 number Maktab Vidyalay in the district of Nagaon to any school in the district of Hosai or to any other nearby place of her residence. The The case of the petitioner, as could be seen from a perusal of the writ petition, is that she is working as the second Shiksha Mitra in Trish Gori Suburi, a new LP school, bracket EGS Center, since 2006. And thereafter, her post was regularized as an assistant teacher and was appointed as an assistant teacher in lower primary school and was posted at Poop Putalzar 3 number Maktab Vidyalay in the district of Nagaon by an order dated 12/9/2017 issued by the mission director SSA Assam. It is the further case of the petitioner that the petitioner is a resident of village Oksek, Tris Gori, Hozai. And as she has been posted in Nagaon, which is at a distance of 120 kilometers, it is difficult for her to function as the teacher, in as much as she has to start for the school at 6 a.m. and returns back home at 9:30 p.m. It is under such circumstances that the petitioner had submitted representations on 29/12/2017 and 10/5/2018 before the Deputy Commissioner, Nagaon, and the District Elementary Education Officer, Nagaon, and the District Mission Coordinator, Nagaon, praying inter alia for transfer from the said school where she is functioning to any other school nearby her residence in the district of Hozai. It has been also mentioned that the petitioner had also filed another application on 16/5/2018 for inter-district transfer of the school teacher before the concerned authority regarding her transfer from the school to a school within nearby to her residence. On 15/6/2019, the District Mission Coordinator SSA Nagaon, by an order dated 15/6/2019 itself, allowed her application and proposed to the Mission Director SSA Assam to transfer the petitioner from Poop Pultarzar 3 number Maktab under Lokwa Education Block Nagaon to the district of Hozai. However, in spite of that, nothing has happened for which the petitioner has been constrained to approach this court under Article 226 of the Constitution. Mr. P. Nayak, appearing on behalf of the Sarva Shiksha Abhichan, that is the respondent number
3 and 5. 3 and 4.
3 and 5,
Yeah.
submits that in respect to those teachers appointed under the Sarva Shiksha Abhichan, the provisions of the Assam Elementary and Secondary School Teachers bracket Regulation of Posting and Transfer bracket close Act 2020, hereinafter for short referred to as the Act of 2020, is applicable. And as such, the petitioner therefore is required now to file an application by online mode for being considered for transfer if the petitioner comes within the ambit of the grounds stipulated in Section 10 of the Act of 2020. Isn't that, Mr.? That is your submission.
Lordship.
This court, upon hearing the learned counsels for the parties and taking into account that the Act of 2020 specifically stipulates the manner in which the transfers can be applied and effected, is of the opinion that the petitioner is required to apply in terms with the provisions of the Act of 2020 and taking into account that the petitioner is having a great amount of difficulties, the petitioner may also the difficulties may apply may apply in terms with the Act of 2020. This quote further taking into account that the difficulties so faced and also the order passed on 15/6/2019, whereby there was a recommendation, directs the Deputy Commissioner, Nagaon, to look into the case of the petitioner in terms with Section 9 of the Act of 2020, and thereupon shall consider the same as per the provisions of the Act of 2020. This court further directs the respondent authorities, more particularly whom?
Let's follow the procedure as laid
Understood.
down in section 9. Now, first you will submit an online application to the Deputy Commissioner. Deputy Commissioner will send it to the Secretary to the department.
Understood.
If you
Whom
recommend-
should we direct that
Ultimately-
the
ultimately-
period within a particular period, no? I'm not saying a direction for anything. Period within what time? Whom should we direct? To the mission director?
Lordship, the respondents will be appropriate, I think.
Whom?
Ultimately, the order will be transfer order will be passed by the mission director.
Okay.
But with recommendation.
This court further directs the mission director, that is Sarva Shiksha Abhijan, that is the respondent number 3, to see to it that if the petitioner applies on the basis of the liberty so given, the said consideration is carried out as expeditiously as possible and preferably within a period of 6 months. Huh? Okay, from 5 months, 10 days. Six months. No, I have only asked them to look into it once we apply.
Lord.
If I don't give this, then they won't work out.
Ultimately, the mission director will pass the consequential order if the secretary recommends.
So once we apply, then within 6 months you need to, as expeditious as possible, preferably within.
Oblige. Oblige.
Yes, Mr. Balvin.
But this matter pertaining my lord overstay in service, my lord. Earlier occasion, my lord, instruction was.
We have received the instructions, Your Lordship. We have received the pair-wise comment from the inspector of school, Your Lordship.
Yes, who are you?
I'm for the department, Your Lordship.
Which department?
Education, Your Lordship.
Education.
Yes,
Okay,
Your
what is your instruction?
There is an overlap writing in the date of birth, Your Lordship, in the service book.
Then? What about the provisional pension?
Yet not paid, my lord. Those are, my lord, some orders were passed, my lord, page 18, then 19, then 20 of my writ petition, my lord. Some orders were passed, my lord, regarding my provisional pension, my lord, page 18, 19, and 20, my lord. But finally, those orders are not acted upon, my lord. But so far, my lord, overstay part is concerned, I had already filed one writ petition, which is pending, my lord. And where this overstay part is also stayed by this our court, my lord. This is page 21, my lord.
Which one?
In this petition, my lord, page 21, sorry, my lord. This page, my lord, 16, my lord.
What is this? The same person?
Yes, my lord.
I passed the judgment?
No, my lord, this is another one.
Okay.
Similar order.
Now, page 21 is some I filed by?
My lord, this is, my lord, I am showing just similar, my lord, order was passed, my lord, for provisional pension, my lord. And my lord, in my case, my lord, this petitioner filed, my lord, another case, my lord, page 16. Page 16, my lord, regarding, my lord, my lord, recovery, my lord. Because already they have, my lord, passed order for my provisional.
Are you saying that the petitioner has filed another writ petition?
Yes, my lord.
Where is it?
This is page 16, my lord. Page 16, my lord.
16?
16, my lord.
Borun Bormon.
Because, my lord, their promoter, my lord, passed, my lord, order for, my lord, provisional pension. Therefore, my lord, I did not file, my lord, writ petition regarding, my lord, my provisional pension or other pensionary benefit, my lord.
When did you retire?
My lord, my lord, true date of retirement is, my lord, 19, my lord.
1990?
No, my lord, 2019, 31/7/2019, my lord. But they, my lord, allowed me to retire, my lord, on 31/7/2021.
Your retirement actual date is?
Actual date is, my lord, 31/7/2019, my lord.
19.
Yes,
And
sir.
when did you retire?
29/2021.
29, 2021.
Yes, sir. 2020.
And how did this happen?
Because, my lord,
Where is your service book?
service, my lord, is lying with them.
You have a copy of it?
Only, my
Mr.
lord.
Borboya, you know, you have a copy of it. Why have you not enclosed it?
Overwriting is there, my lord.
There the problem is. File your affidavit.
Yes. Indirect, my lord, part.
No.
The part certificate, my lord. Therefore, my lord, they have confused and they overwrite it, my lord, wrongly. I have stated, my lord.
No, how can there be an overwriting?
My lord, this is, they have done, my lord. Because, my lord, this is indirectly, my lord, date of part is given in the, my lord, lordship kindly will look my.
No. This is a case by which there's a very important aspect of the matter, because overwriting which is done,
Yes.
then it is a case which needs to be looked into whether there is any case of fraud which you have committed.
My lord, I have not. He has not done, my lord, anything.
Huh?
He has not done, my lord.
Yeah, at your behest somebody else has done.
Yes, my lord.
Yeah.
Because they could not, my lord, find it out, my lord.
Okay, we'll issue notice. File your affidavit. You have
Yes,
got your
Lordship.
instructions, file your affidavit. We'll have it on 15th of December. You
sir.
file your affidavit by 11th of December. Okay. Issue notice making it returnable on 15th of December 2023. Miss, what's your name?
H. Terangpi, your lordship.
So appears on behalf of the respondent number 1, 3,
6, your lordship.
6. Mr. Arbor Pujari appears for the respondent number 2 and 7. Mr. You are Deuri. You are appearing for respondent number 5. And Mr. B. Chakraborty appears for respondent number 4. As the respondents are duly represented, extra copies of the writ petition be served upon them by 14/11/2023. The case of the petitioner herein is that the petitioner had retired on 29/2021, and on account of overstay, for which the petitioner is not responsible as alleged, the pension of the pension and other pensionary benefits of the petitioner have not been allowed. On the other hand, Ms. So-and-so, the learned counsel appearing on behalf of the respondent number 1, 3, and 6 submits that there has been some overwriting in the service book which had led to the petitioner retiring on 29/2021, whereas the petitioner ought to have retired on 31/7/2019. This court is of the opinion that the said aspect of the matter needs to be brought on record by way of an affidavit. Accordingly, the affidavit be filed on behalf of the respondent number 1, 3, and 6 by 11th of December. The petitioner would be at liberty to file a reply on or before the next date. Absolutely no. You are, on the other hand, you are to give back the money only. We'll look later on the next date. You have a copy of the service book. Why haven't you filed?
Obliged.
May I please your
Yes.
lordship matter pertaining to non-payment of terminal benefit.
Yes, why haven't you paid?
These are regarding those Assam Plain Tribes Corporation matters.
Yes,
sir.
we have. I have fixed. What has happened to those lists?
May I just place around
That's 8 crore 26 lakh we have paid last week.
Then
No, these are new.
these are the new lots
New-
now.
new-
There are
new-
3 more cases now been filed presently.
okay.
But those earlier cases, everything has been paid.
Oh, earlier is done. So very
Yes.
well.
All done, my lord.
Something good has happened then.
Yes, yes.
Yes. Okay, we issue notice and we fix it when these are amounts which you need to pay.
We agreed with it. We
And there is another 2 matters.
There are 2 matters.
You have the list.
Lordship,
Okay,
the list.
we fix this matter along with that, or bring those matters along with this.
Lordship may fix the matter along with those steps.
What is the next date fixed?
Lordship, next date not fixed, Lordship.
That is why I'm saying
No, Lordship.
I will fix this and bring those 2 matters along with it.
These will be the new lots of cases now. Which will be also
Issue notice making it returnable by 18th of December 2023. Mr. Ardhor appears on behalf of the respondent number 2.
Yes,
Only
yes,
2.
Only 2, my lord.
2.
I am for 3 and 4 lots.
Mr. A. Sharma appears on behalf of the respondent number 3 and 4.
My lord,
And Mr. Arba Pujari appears for the respondent
my
number
lord, they
1.
should have made it to the department party, my lord. The commissioner secretary, tribal affairs, they should have made a party because, my lord, ultimately the park will stop there, my lord. They are not a party yet. Later on, my lord.
Who is going to pay?
My lord, they are going to pay, but they will come begging for money to us. They will say that we don't have money, government. And
You are there now.
Government is not a party yet.
You are there now. Nowadays, you see, earlier I used to do it. Nowadays, there are a lot of complications to make these people a party. After all these notifications and all.
But, my lord.
I hope now some things normalize.
Yes, my lord. But, my lord, let him make this government a party, or else they are.
Okay. Yeah. Mr. Arba Pujari appears for respondent number 1. Ek ita line to thick koi dibo, ha? R1, 2, 3. Issue notice making it returnable. As the respondents are duly represented, extra copies of the petition be served upon them by 14/11/2023. Full stop. The case of the petitioner herein is that the petitioner is entitled to, petitioner being the legal heir of late Tikendra Deori, is entitled to gratuity, leave encashment benefit, area salary, etc. from the respondent number 3 corporation. The said dues are duly admitted, but however, the said amount have not been paid to the petitioner. And it is under such circumstances that the instant writ petition has been filed. The respondent Yeah. Mr. Arthur, appearing on behalf of the respondent number 2, that is the Director of Welfare of Plain Tribe and other backward classes, submits that for passing an effective REIT, the Commissioner and Secretary to the Government of Assam, Welfare of Plain Tribe and other backward classes is
Tribal affairs now, my lord. Tribal affairs.
Submit that the Commissioner and Secretary to the Government of Assam Tribal Affairs Department is required to be made a party in the instant proceedings. Taking into account the said submission, this court, in the interest of justice, impledes the Commissioner and Secretary to the Government of Assam Tribal Affairs Department as the respondent number 5, having his office at Dispur, Guwahati 781006 as the respondent number 5 to the instant proceedings. First, Mr. Ardhar further accepts notice on behalf of the newly impleaded respondent number 5. Extra copies of the same may be, the petitioner is further directed to serve an extra copy of the said writ petition to Mr. Ardhar by 14/11/2023. First, the petitioner is further directed to file a memo of parties before the registry by 14/11/2023. A fresh memo of party, a memo of parties whereby the name of the Commissioner and Secretary to the Government of Assam Tribal Affairs Department is included as shown as the respondent number 5. The registry shall make necessary correction in the records on the basis of the memo of parties so filed, and as well as also update the same in the CIS.
My name may be shown in the post. My name may be shown in the post.
Your name has not been shown. After writing so many things about you, also there is no name shown. Mr. Ardhar submits that his name also may be shown in the record, in the cause list. Mr. Ardhar, the learned counsel appearing on behalf of the Tribal Affairs Department's name also be reflected by the registry in the cause list.
I have already served extra copy.
We were asked to take instructions on the first day, so one copy was served. But
again,
okay.
Notice.
Oblige you.
Deeply obliged.
Yes, why two matters, two persons having different names are together?
No, there are two cases, two transfer order, my lord.
They are interrelated.
Interrelated, somehow interrelated. I'll paste.
Somehow means because they belong to both to the irrigation department.
Both to the irrigation department, both are junior assistant, my lord. One is senior assistant, one is junior assistant.
Then how is the similarity?
No, there are two transfer order. Your lordship, then your lordship take up, my lord, first, my lord, second, item number 7, my lord, Dhruva Lokar.
7.
7, my lord.
Seven, Dhruva Talukar.
Last occasion, I was asked to produce the record. But
Wait.
Dhruva Lokar, my lord.
Yes, what is it? Where is the transfer order?
Yes, transfer order, page annexure 8, page 30.
Page 30. Yes. So and so is hereby transferred and posted in the office of superintendent in the interest of work.
See, Dhruva Lokar, head assistant of the office of the executive engineer, Bishwanath Sahil, Behla division, irrigation, Bishwanath Sahil is hereby transferred
against the vacant post.
He's been transferred to, my lord.
From where?
From, my lord, Bishwanath Sahil to, my lord, Karimganj.
No, Silchar.
Kasar Karimganj. Kasar Karimganj.
Okay.
Karimganj, my lord. And your lordship kindly see that his order was passed by the chief engineer. And my lord, normally, my lord, the clerical level post, my lord, outside the district never posted. Because the seniority is always maintained in respect of the district only. That is the one reason. Another reason is that, my lord, my brother, he filed a contempt case against the city chief engineer, my lord. And when the contempt notice was issued, my lord, by this honorable court, few days after, my lord, this order was been passed. So my mother is in ill, my lord. I filed a leave application. So that leave application, my lord, I place,
But you can't make that submission.
my lord.
That second submission you can't make without making the chief engineer a party
Party,
by name.
that by name I not made,
You have not done it, don't then make that submission.
my lord. Chief engineer, yes, I by name I have not made party.
Then you can't make. Because you can't allege the office.
My lord, correct. That is true.
That I am not going to do. The first.
So that is one aspect of the matter. Another aspect of the matter, my lord, after 14 months, I am going to retire, my lord. And that is, normally it is not done, my lord. And moreover, my lord, there is a SOP. There is a SOP of the Irrigation Department. That when there is a transfer proposal, there is a committee, they have to place it before the committee. There, for transfer proposal always placed before the committee, and committee will decide. Then only my lord, transfer order was passed. But here in this,
where is the SOP?
That SOP, my lord, probably headed. Yes, yes.
Again, you have not enclosed.
Yes, yes, that is not enclosed, but that is with me, my lord.
With whom? With you. How can you help it? Tell me. Can't help it.
So, my lord, that is my submission. Let them, my lord, place this record, my lord. Where is that proposal, my lord? That your lordship kindly look into.
First of all, how do I know? Unless you bring on record those things.
Then, my lord, already there is a stay out. I give you some time, I will do it, my lord. Already there is a stay
I
out.
will give you some time by vacating it. Yes.
No.
Tell me. Show me the SOP. Is that SOP? So your submissions are twofold. First, you are going to retire in 14 months.
After 14 months.
And as such, you shouldn't be disturbed.
And my lord, normally, my lord, that ministerial level staff, my lord, never.
So the second is ministerial levels staff are normally not transferred unless for exigencies.
My lord. Third, my lord, they have not followed the SOP. That SOP, there is a Irrigation Department SOP that there is a proposal has to be submitted.
Of public service.
Clause 8, your lordship kindly speak. Clause 8. A8.
Are you saying that the ministerial level people are not transferable?
Transfer normally within the district, my normally within the district, because always there, my lord, seniority is maintained district wide. And my lord, your lordship kindly see that that SOP clause A.8.
Now, why are you saying normally?
Sometimes usually it can be done.
But why you are saying normally it is done, ministerial stuff is not transferred?
Because my lord, always seniority list is, my lord, prepared as part of district wise. Suppose I am with a senior in one district, I may not be a senior in another district. But that is why, my lord.
But Lordship, head assistant, he is serving as head assistant, Lordship, with the topmost post of the office. Lord. So it can be, as per my information, though I do not have the record to say, but he can be transferred, Lord, head assistant. The other case, Lordship, item number 6, Lordship, he can argue this point, Lord. Junior assistant.
Head assistant, he becomes the head assistant.
He is a single post, Lordship, in the district, Lord.
He's promoted.
No, not promoted, Lordship. He is a head assistant.
No. In the interest of public service, so and so senior most junior assistant, under this is promoted.
No, that is my earlier.
To the post of senior or senior assistant. This is the first order. Where is the transfer order?
Transfer
30,
page
page
30.
30.
Page 30. In the interest of work, so and so, hereby transferred and posted in the interest of. So what is the reason for transferring?
Lordship, for the interest of work, Lord.
What is
His
that?
experience, Lordship, is to be used there in the that office, Lordship. That says the note, Lord.
Interest of work. We've all along heard about interest of public service,
Yes.
public
Of course.
interest. What is this interest of work?
Lordship, I kindly peruse that and note 2, Lordship. Take middle one. Yes, Lordship, it is.
When was the order?
7th of, that is order was
7th October.
7th October 2020.
7th October 20.
Approval of order. Rest on
Now, what will happen to the head assistant in this place?
that is Lordship probably explained there, Lordship, in this note itself, Lordship.
No, you are transferring him to Silchar.
Lordship.
The reason is that in Silchar there is no head assistant.
And he
So that he can go there and pick up somebody.
Lordship, the new Lordship offices has been now Lordship topped up due to the Lordship.
Okay. So he can pick up somebody
Lord.
from there and show him. But what will happen here? Because the reason has to also gel, na?
Lord.
What do you say about that? See the reason.
Yes, Lord.
Huh? See the reason? Did you explain?
I don't think
Huh?
I don't think there is anything else. Lord.
Understood.
Lord.
But how do you take care of that? Means, see the reason. So
Yes, Lord.
One should go and other will come. But here only one.
no. The reason why you are sending him is that there is no person out there.
But if he'll go there, he'll be vacant here.
It was transferred against a vacant post, Lord.
Understood.
Yes, Lord.
So what will happen here? See the reason. How do you tackle with that issue?
And Lordship, that is Lordship is correct, Lord. Gateway Lordship is correct. Because here they have not said Lordship whom they are posting here in this paper.
There has to be some reason
Lord.
why you are filling up some post and not here. Although there is somebody out there essential.
No, there is no Lordship. Lord.
There is somebody who is at Silchar, who is the senior assistant, having been given the in charge, but he's not getting the salary because he cannot get the salary unless he is promoted. So, but the fact that he is getting the works done, the fact that in the interest of works, can you say it to be in the interest of works when the work is done? Or is it in the interest of the salary to be paid to that person who is not getting the salary although doing the work of an in charge.
That instruction I have to take.
I think you should file an affidavit this thing, because why I am saying an affidavit is required. Something has to be taken care of here also.
Yes. Notice notice, court
I think
notice.
notice is to be issued. And I don't like this habit of not issuing notice, keeping it for motion.
No, that day he said that I'll publish the record. That's why.
That whatever whoever may say. That is going on from 1910 over. One day also notice, because how can you disturb him unless you issue a notice? They are also statutory functionary. Okay. Issue notice making it returnable when?
3 weeks.
Okay. Issue notice making it returnable on 13th of December. Giving me my unlucky number. 13th of December 2023.
Always back in touch.
Mr. Enupadhyay appears on behalf of the respondent numbers 1, 2, and 3. Yes, sir. Extra copies of the writ petition be served upon them, served upon him during the course of the day. This court further takes note of that during the proceedings, Mr. Enupadhyay had produced the records wherefrom it is seen the reasons why the petitioner was transferred by the impugned order. From a perusal of the records, this court finds it relevant to make an observation here that from a perusal of the records, it reveals that a petitioner has been sought to be transferred from Biswanath, from the district of Biswanath to Karimganj or Silchar.
Kasai Karimganj circle.
To the
There is circle is called Malar Kasai Karimganj
to
circle
the
irrigation.
to the office of the superintending engineer, Kachar Karimganj Circle, irrigation Silchar, on the ground that there is no other person working as a head assistant. It further transpires that at present, the senior assistant in the said office is functioning. He is also carrying out the additional charge of the head assistant. And as the said senior assistant cannot draw the salary of the head assistant unless he is promoted, the petitioner has been sought to be petitioner have been transferred by the impugned order. This court had put a specific query upon Mr. Enupadhyay, the learned counsel, appearing on behalf of the irrigation department, as to what the department had proposed in respect to the office of the executive engineer Biswanath, Behali division, where the petitioner is presently functioning as the head assistant. The learned counsel submits that he would like to take instructions and file an affidavit. List the matter again, list the matter. That said, taking into account that this court had already fixed the matter on 13th of December 2023, the affidavit be filed by 7th of December 2023. The petitioner thereupon shall be at liberty to file a reply. The interim order passed earlier shall continue till the next day.
Next one, my lord. Your lordship,
Yes.
Your lordship, kindly see Annexure 4, my lord, page 22. I am a junior assistant of that same office. Page 22. That is a so-called notice issued to me, my lord.
Wait, page?
22.
So with reference to the I am to inform you that yes, what is wrong?
Very next day, my lord, transfer order are issued. The very next day, my very same day, my lord. Very same next one, page 20. Page 20.
Yes.
So same day, my lord. Notice was issued, same day transfer order issued. And I am giving reply to owner, reply in page 27, my lord. Page 20. Sorry, page 25.
Page?
Page 25. Is my reply, my lord.
Yes. The honor to inform you that Rupata is the other one.
Other one, my. So his leave application was, my lord, and photocopy I have signed, my lord. Now they say that why you give it to him, my lord. Necessarily, my lord, we receive it, my lord. We put my signature and photocopy. I have given the photocopy. Main copy I have keep, my lord. Photocopy I have given. Annex 7, my lord.
Then no. Who has transferred you? Irrigation, chief engineer, irrigation Assam.
Now again, chief engineer.
He is the authority to transfer.
Actually, nowadays, my lord, as per SOP, my lord, there is a committee has to offer. The proposal has to submit the
Who transfers, Mr.
chief engineer?
Lordship. In which case, chief engineer has transferred lordship. Otherwise, lordship, the executive engineer can also transfer.
No, who is the authority to transfer? Is it the department? Or the department has delegated the power to the chief engineer?
I have to check that in. I want to check that in.
Again, interest of the work, my lord. Again, interest of work.
Interest of work is very important.
My lord, again, my lord, to another district. The same, my lord, where is the Dhokal of for? That was the link, my lord.
But Mr. That case, okay, we have looked into it. But at the end of the day, you are having a problem. How do you allege malafide without making that person by name in past first as party?
In this case, my lord, that case, my lord, I'll make party, my lord. But here in this case, my lord, error apparent, your lord, same day, my lord, my notice was issued, my focus notice was issued, and same day transferred, my lord. I can there did a waiting for my lord my reply. And my lord, therefore, your lordship kindly see that cause, my lord. I have received it. Yes, that is correct. Absolutely correct. There is no question of any inquiry. Because as a
why has he been transferred?
Record he was asked to produce the record, my
lordship. There is not note in fact. Only big not is there. There is no reason lordship given in fact. What time to be thanked.
This much?
This much.
As directed, an office order draft is regarding transferring to
Lordship may interfere with this.
As directed by whom? a directed office of the state. Nothing else.
Nothing, I have not find anything else, Lordship. I have not find, Lord.
We'll take it up at 2. Find it out. If you have, I'll dispose it of.
Lordship may dispose it of.
I'll dispose it of. Have a look.
Lord.
Because your thing is, I've not been able to find it properly. So we will look into it. I'll dispose it of. If this is the only thing written out there, my goodness. I'll set aside this transfer order. Let him reply that disciplining proceedings will go. You have a look at it. We'll take it up at 2.
At 2, my lord, I get to accommodation. I have another. I will come back.
Oh, good. So that he is
My lord.
appearing. Mr. Dekka is appearing. Mr. Mohanto doesn't wish it. Yeah.
Not to instruction received, Lordship. File affidavit.
Huh?
Instruction received, Lordship.
What is this? It's a case of
This case is sexual harassment in the workplace, Lordship. Sexual harassment in the workplace, Lordship.
Oh, then?
Serious allegations are there, Lordship.
So what is
An
the
internal
allegation?
committee was constituted and found that
Is hereby placed under suspension. What is the reason whereby so and so is hearing the complaint is submitted by
these are the instructions, Lordship.
the allegation is that the 5/10/2023.
Now, Lord, to kindly see, my lord, page 15, the apology letter submitted by the petition, page 15.
Yes.
Yes.
What is your case?
My lord, page 15, Lord, to kindly.
So what? So what? You have been suspended out there. Why should this court at all interfere?
Now, under the, my lord, act, my lord, and the rules, my lord, there is a, my lord, provision. Then, my lord, the respondent can be transferred to any other establishment. And the
No. You have been put to suspension.
Yes.
You are challenging the suspension
My
order.
lord.
Now the suspension happened on 5/10/2023.
My lord.
So under such a, why should this court at all interfere or exercise 226?
Because under the provision of the, my lord, Sexual Harassment Act and rules, my lord, there is a provision for transferring the, my lord, respondent.
Whatever may be, but the fact that you have done something for which they want to initiate departmental proceeding,
That's fine, that's fine.
so they can very well suspend. That the power is there.
The rule says, my lord, suspension cannot be, my lord. There is a rules, my lord. Rule says he can be transferred to the other establishment.
But no suspension.
Yes, rule says, my lord.
What does it say?
Yes. But kindly see.
There cannot be a drawing of pending departmental proceedings.
Yes, that can be, my lord.
So does this rule or the act
My lord.
override the discipline and appeal rules?
Since it is a, my lord, special act, my lord.
So what? Where is it?
Yes, lordship, kindly see.
Which provision?
My lord, section, my lord, rule, my lord, 7 of the rules 13.
Subject to the provisions of at the time of filing the complainant shall subject to the complaint 6 copies of the content supporting the chief of the complaint
Section 12, Lordship kindly see.
Huh?
Section 12 of the Act. Section 12.
Yes.
Yes. Action during pendency of the inquiry. During the pendency of an inquiry on a written request made by the active man, the internal committee or the local committee, as the case may be, may recommend employer to transfer the active woman or respondent to any other workplace. Grant leave to the active woman or up to date so and so. Grant such other relief to the active woman as may be prescribed. They have granted the active woman under this section shall be in addition to the leave and will be otherwise entitled. On recommendation of the internal committee or the local committee, as the case may be, under so and so, the employee shall so and so under section.
Where is it? This is an inquiry under this act.
Yes.
I'm not, but disciplinary proceedings is different.
Yes.
Then what is wrong?
Now, wrong, my lord, lordship kindly see the provision by which my lord he has been suspended. It is not also applicable. Lordship kindly see.
Instruction forwarded, Lordship. That instruction was forwarded, Lordship.
It says, my lord, rule 2. Rule 2 is not 6.2 rule is not applicable.
6.1 is applicable.
6.1 is applicable.
6.1 is not available here.
We'll make it clear.
Order,
We'll make it clear that this order should be read as done under 6.1. Is it?
6.1.
You want to do it?
6.1 is issued, Lordship. Corrigendum is issued, Lordship.
Corrigendum issue.
Lordship.
now, let them punish the corrigendum. We will.
Not necessary. Dismiss. Withdraw. Which one? Either of it. Dismiss. Observation. Withdraw. No observation.
Liberty may be given to petitioner to file an appeal before this competent authority.
Fantastic.
Against this.
The learned counsel appearing on behalf of the petitioner submits that in view of the fact that the order dated 5/10/2023, in view of the fact that the order of suspension is only dated 5/10/2023, he may be permitted to withdraw the instant writ petition with the liberty to file an appeal as provided under section 15 or 10. Disciplinary appeal rules, section 15.
16. 16.
Under section 15 of the Assam Service Bracket Discipline and Appeal Rules 1964. 15. 16. So, taking into account the above submission, the instant writ petition stands closed on withdrawal. The withdrawal of the instant writ petition shall not prejudice the petitioner to assail the order of suspension under the provisions of the Assam Services Bracket Discipline and Appeal Rules 1964.
9.
Yes.
Clear, please, your lordship. First, I will seek your lordship permission. My name is not there.
Not necessary. Tell me. I don't
Your
put
lordship,
anybody's name on.
It is the entitlement of payment of minimum of the wages to the casual workers who were
Oh, that
engaged for
one.
online.
As per that judgment, Upendas.
Yes, readable 45/40, 2040.
And
Readable 45.
you were prior to that.
Yes.
You were appointed prior to 1/9/2005.
Yes. Annex 1 is there.
Hello. We issue notice.
My lord, this matter can be disposed of, my lord.
Can be disposed of.
His main grievance is that PNRD had not forwarded his name in that pre-FRBM list to the finance department. There's a similar matter which has been annexed in this writ petition.
Annex 6.
Annex to 6, my lord.
15. With that observation, it can be also disposed of.
But the Commissioner PNRD needs to verify his appointment.
Counsel, let me tell you one thing. Why I know this order, why I should not pass this order. If I pass this order now, he would never get anything. The reason is this. Finance is going to tell. So what is wrong? PNRD keeps on sending one after another, We have asked them. There has to be a stop somewhere, but they are not. They're coming up every time. We need to look into it. His submission. I've got many matters of this type when I was sitting in this bed.
Not, in fact, even if you file an affidavit in this matter,
No, your affidavit is not required.
finance is approved.
When I notice you get your instructions. You have to only, on your instructions, you have to say that you have forwarded. And he is also going to tell that what is it. Then that order has to be passed. There were similar matters which were there before this court. And his submission was that. What has happened to those matters in the meantime? Disposed? They've got it.
But that perhaps we do not know because that will have to be routed to the PNRD administrative department.
No, administrative department will send it to the finance. Unless the finance approves, you can't pay.
Yes.
Now the finance only thing is, as I remember that submission you had made, that PNRD is the only department which is keeping on sending name after name. There are 8 lists, isn't it?
Yes.
8 lists. There were 2 matters which were pending when I was sitting out there. I don't know what had happened there. There were 8 lists. And those people's names were very much there in the 8 list. And who was appearing earlier?
But his grievance is that his name is not there in the initial list.
Understood. His name will be there. You will come up that we are going to send it. But he is going to call the breath. So notice has to be issued.
That's my Lord Direct.
If I dispose it of, he won't. It's only a case of contempt. Later on contempt, and after 4 or 5 years, it will be, that can't be done. Nothing is, it keeps on changing. Nothing is going to. No. You want an effective relief or just a relief? Issue notice making it returnable on, get your instructions by 11th of December. Issue notice making it effectively returnable on 11th of December 2023. Mr. P. Hendrick appears on behalf of, oh, how much court fee? Everybody paid court fee?
Yes. Yes, sir.
1, 3, 4, and
Yeah.
5.
10.
Mr. Hendrick, P. Hendrick appears on behalf of the respondent number 1,
3, 4, and 5.
3, 4, and 5. Mr. Arbo Pujari appears on behalf of the respondent number 2. As the respondents are duly represented, extra copies of the petition be served upon them, upon the learned counsel by 14/11/2023. The case of a petitioner herein is that the petitioner were employed under the Panchayat and Rural Development Department as casual / master role worker prior to 1/9/2005. And they are entitled to the benefits of the minimum of the scale of pay, that is at the rate of rupees 15,000 per month, 15,900 per month, along with medical allowance at the rate of rupees 600 per month. As per the judgment of the division bench of this court in the case of Upendas versus State of Assam. State of Assam or Upendas or Upendas? State of Assam versus Upendas, dated
18/6/2017.
huh?
18/6/2017.
8/6, my Lord. 8/6/2007.
8/6/2017. It is being aggrieved by the inaction on the part of the respondent authorities in not making the payment and not granting the petitioners the minimum of the scale of pay. As per the judgment of the division bench of this court, the petitioner has approached this court. The learned counsel appearing on behalf of the respondent shall obtain necessary instructions as to why the petitioner have been not paid in terms with the judgment of the division bench of this court in Upendas Supra. This recording. 10. Yes, madam.
Lordship, may I kindly be allowed to withdraw this petition? As there is technical issue.
Huh?
There is technical issue.
You want to withdraw?
Yes.
And no liberty. Oh. Withdraw, why? You set aside and call. Oh, you have been reinstated.
No, I have, this is the only instruction I received from my senior.
What had happened?
this petitioner has misled the petitioner counsel, the petitioner, the person who is before that. He is already, there's another round pending on the same cause of action. So in the morning, Mr. Sarania was there. I informed him that the person has, and it's an interesting case, madam, this person is absconder.
He's an absconder,
He's
and he has
still an
filed a
absconder.
petition before his court.
Yes, my lord. He's still an absconder wanted in a forest for case. And my lord, in that case, my lord, on the day of motion, my lord, I was asked to bring instructions. On the day of instructions, the petitioner's counsel on the other matter, they, my lord, sought time, and it has never been listed. And this person, Arup Bosho, he did not inform Mr. Sharonia that another round is also pending. It's 690.
You have the number?
69023.
The learned counsel appearing on behalf of the petitioner submits that she has instructions that the petition, she has instructions to withdraw the instant petition. Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that the reason why the petitioner is withdrawing the instant petition is in view of the fact that in respect to the same cause of action, another petition
Number
being WPC number
69023.
690
of
oblique
2023.
2023 have already been filed before this court, wherein this court had already issued notice. Taking into account the above, the instant petition therefore stands dismissed on withdrawal. I am putting that, otherwise I wouldn't, but this would, I'm putting it so that this is kept on record, what he has done. Yes. Why? What is the matter about?
My lord, they are challenging the speaking order after pursuant of the High Court judgment. High Court had asked to pass a speaking order. The speaking order is at
Matter pertains to what?
Matter pertains to my employees who have been rendering service for 10 years or less.
Yes, yes. Tell me, what is your case?
Lordship, we're working as Sahayak under APTC, Lordship. Lordship, we prayed for a similar direction from this Honorable Court to consider our case for one-time consideration. Since we have completed more than 5 years of service. Lordship, this Honorable Court, my Lord, by the order dated 24/5/2023, Annexure 6, my Lord. Page 55.
What is this 10/8/2023? Where is that order?
10/8, your Lordship. 10/8/2023 order is at page 67.
This is the order you are challenging?
Yes, Lordship. Because our prayers were not considered in terms of honor. Lordship, there's a direction to consider our prayer for one-time consideration, my Lord, which is not considered, my Lord.
What do you want?
Lordship, our prayer is that the cases of similarly situated persons were considered, and some of the persons were not similarly situated and worked for less than 5 years. Their cases were also being considered. Just one-time consideration as regards pay protection, my Lord, in terms of Honorable Court's order. So, Lordship, that was not considered, and in the payment records, wrong dates were shown, my Lord. So, on the point, on the plea of equality, your Lordship, we have preferred this petition, my Lord.
What was your prayer before this APTCL authority?
Lordship, my prayer was done since this Honorable Court passed an order directing the respondent authorities to give one-time consideration
for what?
To the persons who have worked for 10 years and who have worked less than 10 years for pay protection, my Lordship. May I refer to your Honorable Court's order, various orders, first from page 25 onwards, my Lord.
Page
25 onwards. Various courts have passed similar orders, your Lordship. Page 25, page 39. Page 39 is a relevant portion. Lordship, last portion. As regards any of the petitioner who may not have satisfied the requirement, page 39. Yes.
As regards any of the petitioner who may not have satisfied the requirement,
Then we prefer a writ petition also, and our cases were also been considered.
Similarly, similar order.
Yes, my lord, at
Then-
page 60.
So you
So we
ask
prefer
for,
presentations.
you ask that this court should pass an order requesting them. to
No, that
consider-
order has already been passed.
No,
That
that is
order,
what,
yes,
that is what.
Yes.
Requesting them that they should consider.
yes. So
Now they-
accordingly,
By this impugn order, they have
rejected
reject-
our prayer. Lordship,
rejection, reason is,
Lordship, financial burden, your lordship.
then why should this
Our
court at all
cases,
interfere?
yes, our cases is that when the cases of similarly situated persons are considered and some of the persons who are not similarly situated, their cases were also
You
been
have not
considered.
completed 10 years.
No, the
You have
persons who
completed
have
some 334
No,
days.
that observation itself is wrong.
Huh?
That observation as reflected in the impugn order itself is wrong, my lord. We have worked from 2016, even when working on holidays, because your lordship understands the lordship is the emergency services, APDCL, my lord. Even on Saturdays, Sundays also we work. So even if your lordship counts
But tell me,
2016,
can this court direct
my lord,
them to appoint?
no.
Then-
Lordship, because the observations which have been reflected when they consider the cases of other similarly situated persons, why we have been deprived of, my lord? We are just
They
paying
don't have the
Sahaya.
financial resources.
Only why, as it is asked, my lord, all these
No.
5 petitioners.
Others have been
Yes,
appointed.
lordship, they have under
No, my lord.
consideration.
No, my lord.
So you have
Absolutely.
mentioned now the 800 employees.
Yes, my lord, that's absolutely.
Moreover, there are more than 800 identically placed person, and the APDCL would not be in a position
Yes, my
to
lord.
single out the petitioner for granting special economy by ignoring the claims of others similarly.
My lord, may I just place it here, my lord? My lord, may I just refer to page 39 of the writ petition. What was stated in the Uma Devi was that any person who had completed the service of 10/4/2006 would be liable for the.
Devi?
Yes.
How does Uma Devi come in?
Yes, my lord, their case does
Uma
not follow.
Devi, paragraph
My lord, may
53 is in respect of 10 years
Yes.
without any order from
My
the
lord, they have
court
not
and further in respect to sanction post.
Absolutely, my lord. My lord, they have not completed 10 years of service. For them, the Honorable High Court directed as regard any of the petitioner who may have not satisfied the requirement of having worked continuously 10 years, we request the respondent APDCL to yes, request. It was just a request. So we took the request and we found out that they have not completed the 10-year service as required under the first paragraph of the judgment. And in the second part of the judgment, quoting Uma Devi and quoting the sanction therein, my lord, we said that we cannot give you this because there will be economic burden to us. And we have said more than the identical placed person and they would not be in a position to single out the petitioner.
What do you propose? This coach.
My lord, at this stage, my lord may, if my lord would like to go into the entire issue to decide that the notice has to be issued. Rather than that, my lord, and even the court.
Did we give a Diwali bonus of issuing just the notice?
No, my lord, there is no bonus. APDCL is in a huge burden, my lord.
No. I'm saying, should I give a Diwali bonus to the council for the petitioner by just issuing the notice? Nothing.
My lord, I would not be in a position to say that, but my lord, at page 60.
Because otherwise, this is a pure and simple case for dismissal.
Yes, absolutely, man.
I am saying,
yes.
Should I give a Diwali bonus?
My lord, facing the court, my lord, I would like to say that this is a proper case of dismissal because there was only a request and there was no proper direction that and the writ that should have been. It's a proper case of dismissal, man.
I am a paid temporary judge for this type of matter. I'll have it on that this matter be discussed next.
My lord has given an immodest judgment and has been reported in GLR.
I am very temporary out here for this bench today. But this bench was earlier of Justice Jamil.
My lord.
Then as he's now sitting in the division bench, the matters have been listed out. I am otherwise a bench 5 man. So I will do one thing. I'll have it next week on Wednesday because the conscience of the court does not permit for issuance given.
My lord, then dismiss them. My lord,
No,
the
I
court.
won't. Let it come upon.
Lordship, but I don't have a case.
You don't.
Lordship. No, I don't think, my lord. I don't have a case.
I think you don't have it. This is the matter again on 15/11/2026. The request of the learned counsel.
Lord, can it on Friday, 17?
17/11.
Okay.
For motion. The request of the petition. Yes, Mr. Bhatri.
That pertains to non-payment
We
of
don't
penalty
see you
income.
nowadays.
The husband of the petitioner serving as Gaon Panchayat secretary.
Huh?
Gaon Panchayat secretary. He
Hmm.
joined in the year 1994.
Is the area death benefit and monthly family pension or fit along with interest per rule 1? What is it?
My lord, the Gaon Panchayat secretary, husband of the petitioner, and died during the course of service in the year 2006. My lord. And fact is that, my lord,
2006.
my lord.
What are you doing?
My lord, kindly, my lord, in the year 1272 numbers of Gaon Panchayat secretary, my lord, joined in the year 1993, my lord. And subsequently, my lord, in the year 2003, my lord, is there for post regular.
Hey, to item number 6 Yes, when did you die?
Died in the year 2006, my lord.
Yes, then
my lord, the 1272 numbers of Gaon Panchayat secretary, my lord, the respondent, my lord, please taking a plea that, my lord, is entrance under the new pension scheme, as because they are post created in the year 2006, my lord. And subsequently, my lord, the writ appeal, my lord, kindly see, my lord, Annexure 7. Is page 31, my lord. This honorable court held that, my lord, the first type of government secretary entitled, my lord, under old pension scheme. Page 31 and operative portion kindly see page 47. Page 47. Conclusion.
in view of the above discussion, yes, what is the issue involved here?
Issue, my lord, mainly, my lord, regarding old pension and new pension, my lord. And my lord, kindly see, my lord, government order page 28. They decided that, my lord, the first type of Gaon Panchayat employee, my lord,
Okay, then what do you want now?
my lord,
Now, because of
I
this
filed
judgment,
representation, my lord.
now because of this judgment, your right has accrued.
My lord.
When a person died in the year 2006.
My lord, yes, because, my lord, this issue is already, my lord, by this writ appeal, my lord, it is settled that the such type of employees get entitled as per old pension scheme, my lord.
Where is it mentioned? Old pension scheme.
My lord, writ appeal, my lord, conclusion, page 47.
No. The coordinate bench was dealing with the decision of the learned single judge which upheld the entitlement
Kindly see, my lord.
of some council secretaries who were working on the thing.
Single bench order, my lord, kindly see page 22.
Now tell me, the posts were created when?
My lord, created in the year 2006, my lord.
No. Posts were created on 35/2003.
It is, my lord, subsequently, my lord. It is
No.
stated there.
You see, this is a judgment where the question arises out here, the posts which were created within these 3 years.
My lord.
These posts were created on 35/2003. And if these posts were created and you died in the year 2006, do you have the qualifying service?
My lord, minimum 1 year of service, my lord.
That is only for family pension, minimum 1 year,
Oh,
not for the
I am
other
seeking family
benefits.
pension, my
No.
lord. 140, rule 140, my lord. Minimum 1 year of service required, my lord. And rule 142, 41 and 42.
Are you saying that a person who works is not going to get pension, but family pension will be payable?
Table, my lord, rule 140.
Can't be. That is a very difficult proposition. What do you say, Mr. Purposary? Can it be so that a person has to have 10 years minimum for the purpose of pension to get pension? But if he dies, he'll get a family pension.
During service, if he dies.
During service, my lord, qualifying period is 5 years. He will not get pension.
But his wife will get.
There is a provision. 142.
No, that I know. That I know. But can it be so? If the person who works doesn't get pension, but his wife will get if he dies?
There is a legal system, my lord.
This point never came up.
No. There's a reason why. Kindly see 140.
Yeah.
This person will get provided he has been getting pension.
Yeah.
See 142 or 141 or 143 2 or 143. That is what, if I remember. If he is getting pension, then only he will get it, family pension. Otherwise, it can't be so. Because I remember one case, I delivered one judgment where a person had see this family pension 140,
142 tells about my lord of 7 years of continuous.
No. Yes. Except as otherwise provided in 142, a family pension not exceeding the rate pension will be admissible in the case of death of an officer while in service or after retirement on or even if at the time of the officer was in receipt of compensation,
Yes.
invalid, retiring, or superannuation. In case of death while in service, the government should have completed a minimum of 1 year. So this is on the basis of which you will get it.
Second line.
Second part he said, but second part is may not qualified by the first part. Because the first part, because here is a case where there has to be a individual entitlement at the first instance. Only thereafter, the entitlement of family will come. Lordship is kindly have a look, at rule 142. 142.
Yes.
Not extending the.
If a government after rendering minimum of 7 years dies while in service, the family of such servant may be granted a pension at the rates of so and so for a period of 7 years so and so. The pension payable thereafter shall be at the rate of
Pension payable in this section will be 50% of the basic pay last one, subject to a maximum of twice the pension admissible under Rule 141. So 142 makes the qualification of 7 years of continuous service.
Yes.
And Rule 140 makes the qualification of
1 year.
1 year, but it is not qualified with the word as continuous service. So meaning thereby, if it has to be read as a whole, the first part will come into play. One has to be a person, an employee has to become entitled individually to the quantum of then only the family pension will go. The family pension is a consequence of his death of an employee. Unless and until an employee doesn't attain the status of
that is what I'm saying. if a person dies, well, see the consequence, what he is saying. In view of that 139 or whatever, that particular thing, 73 or is that 110, nah?
Yeah.
110. Or this 108.
108B.
108, a person, if he has minimum of 10 years, then he will be entitled to pension. Otherwise, he will be entitled to terminal gratuity. Now, here is the case. But if he dies in service, would that be applicable? In view of 140? Huh? Obviously, notice to issue, but when he has raised an important point, this needs to be. But this will have a because that judgment which was delivered by the division bench was on a different aspect. But while doing so, this aspect was given because I remember this judgment, I have read it. The single judge passed an order giving much more benefits. This benefit was reduced by the division bench. And whereby it was mentioned in such other things. This needs to be further examined. So that is another thing. But chalo, we'll issue notice.
Secretarial Civil Services pension rule also is correct. There is perimeter provision slide 108. Here also minus for Secretarial Civil Service, the qualifying period is minus 10 years. There also 10 years, there also it is 10 years. Even except this appears to be the solitary provision. Of course, in the second part of that rule 1.
No, a person who has otherwise completed 1 year of permanent service or continue proper service, he would be obviously entitled to if he dies during service. That is what his contention is.
So it will be, it is only for the family pension.
I'm saying about the family pension.
Only for the
Because the fact that he is going to, at the end of the day, he may have got, at a later point of time, he may have to cross the 10 years or 15 years, he may have qualified. That is the reason why 140 says that he will get, if he died during service. That is the difference. Now, but if a person otherwise has continuous service of 7 years and does not die and retires, then he would not be entitled to family pension, even if he dies one day thereafter.
It is why minus this rule 140.
Issue notice making it returnable on. We'll have it in which year? This year? Okay, issue notice making it returnable on 8th of December 2023. Mr. P. Hendig appears on behalf of the respondent number 1,
4 and 6, my lord.
4 and 6. Mr. Arba Pujari appears on behalf of the respondent number 3 and 7. And Mr. C.R. Hazarika appears on behalf of the respondent number 2
And 5.
and 5.
C.S. Hazard.
As the respondents are duly represented, extra copies of the petition be served upon them by 14/11/2024. 23. The case of the petitioner herein is that the petitioner is entitled to the family pension in view of the fact that her husband had rendered service for more than 1 year and expired while in service in the year 2006. As the respondent authorities have refused to pay the monthly family pension, the petitioner has therefore approached this court under Article 226 of the Constitution. The respondent shall obtain the instructions on the next date.
Item number 13,
Item 13 is of civil.
But
Same order will follow.
date of death,
Respondents are also.
date of death, date, even date, date of death.
When?
In this case, in that case, in the.
In fact, my lord, in both the cases, he had
14
filed a representation
On
before the
39
commissioner.
2023. 15.
My lord may dispose of the matter by
I know,
directing
this-
the.
this court won't dispose of. I'm not, I don't direct authorities to consider
As much
unless. Anything else?
Nothing, Lord.
देखो, the instant writ petition has been filed by the petitioner challenging the order dated 12/10/2023 issued by the Chief Engineer Irrigation Assam Guwahati Irrigation Department issued by the Chief Engineer Irrigation Assam, whereby the petitioner was transferred and posted in the office of the Assistant Executive Engineer, Ratabari Subdivision Irrigation, Ramkrishna Nagar, under the office of the Executive Engineer, Ratabari Patharkandi Division Irrigation, Patharkandi, against the vacant post. A perusal of the writ petition reveals that the petitioner herein has been was discharging his duties as the junior assistant office officer.
Yes.
Junior assistant officer
No, my lord, I am the assistant, my lord, office of the executive
Uh,
engineer.
was discharging his duty as the junior assistant in the office of the executive engineer Biswanath Bihali Division Irrigation, Biswanath Sariel.
My lord.
Full stop. On 12/10/2023, the executive engineer Biswanath Bihali Division Irrigation had issued a show cause to the petitioner stating inter alia that one Dhruvo Lokor, head assistant Biswanath Saril, Biswanath Bihali Division Irrigation, had submitted an earned leave application on 9/10/2023. The said earned leave application was kept in the table of the executive engineer and was available in the dark file without sign and signature of any office personnel. It was further mentioned that the chief engineer irrigation Assam had informed the said Dhruvo Lokar that the said Sri Dhruvo Lokar had filed a petition where he had also submitted a copy of the earned leave application received by the petitioner. On the allegation that the petitioner had made a photocopy of the earned leave application without informing the executive engineer and handed over the same to Sri Dhruvo Lokar, head assistant, it was alleged that the petitioner committed a fraud by providing such document to Sri Dhruvo Lokar without informing the executive engineer. And it is under such circumstances the said so-called notice was issued. asking the petitioner as to why disciplinary proceedings should not be initiated against him, thereby giving him 2 days' time to reply. On the very day itself, the impugned order was also issued by the Chief Engineer, Irrigation, whereby the petitioner was transferred from the office of the Executive Engineer, Biswanath Bihali Division, Irrigation, Biswanath Sarili, to the office of the Assistant Executive Engineer, Ratabari Subdivision, Irrigation, Ramkrishna Nagar. It is the contention of the petitioner that the said order impugned in the instant proceedings suffers from malice in law, as the same was without any basis. And it is under such circumstances that the instant writ petition was filed, challenging that the impugned order of transfer dated 12/10/2023. This court, by an order dated 18/10/2023, had duly observed that prima facie it appeared that the order of impugned order of transfer dated 12/10/2023 was by way of punishment, and as such had directed the Standing Council of the Irrigation Department to produce the records. This court further, in the interim, had also stated the impugned order of transfer dated 12/10/2023 till today. Today, when the matter was called up, Mr. N. Upaite, the learned counsel appearing on behalf of the petitioner, on behalf of the Irrigation Department, had produced the records. Surprisingly, the records do not spell out any reasons or even the basis for which the impugned order of transfer dated 12/10/2023 was issued. A perusal of the records only show that the draft notification was directed to be prepared for transfer of the draft notification was directed to be prepared for the purpose of transfer of the petitioner. And on the basis of that, the impugned order of transfer was issued. This court have duly heard the learned counsels for the parties. It is a well-settled principle of law that transfer, being an incident of service, the jurisdiction to interfere under Article 2 to 6 of the Constitution is limited. The exercise of jurisdiction under Article 2 to 6 as regards orders of transfer can only be done when an order suffers from malice in law or malice in facts, as well as is private on the face of it arbitrary and unreasonable. Taking into account that the records are completely silent as to why the petitioner is required to be transferred. And further to that, coupled with the fact that on the same day, the show cause notice was issued and the transfer order was also issued. This court is of the opinion that the impugned transfer order suffers from malice in fact, malice in law. Consequently, the impugned transfer order therefore set aside and quashed. With the above observations and directions, the instant petition stands this court.
I know 68 supplementary list for motion.
Yes, madam.
In this petition, my lord, I filed an IA, my lord, treating the borrowland.
Yes.
They have to be implemented, my lord.
Who?
Borrowland, my lord. Page 3 of my IA.
You filed an IA?
Yes, my lord.
For what?
For implementing the borrowland.
Impleading the
Borrowland officers, my lord. That from 4, 5, and
BTC.
6. Borrowland Territorial Council, represented by Principal Secretary. 4, 5, and
implead Boroland Territorial Council represented by so-and-so, Director of Education, so-and-so, and so-and-so. To be impleaded.
4, 5, and
I cannot let you. The instant application has been filed for impleading the Boroland Territorial Council represented by the Principal Secretary BTC Pokrajar. Number 2, the Director of Education BTC Pokrajar BTAD Assam. And number 3, the Deputy Inspector of Schools Bheragaon, Subdivision Bheragaon, PO Bheragaon under PS Tongla in the district of Udalguri as the respondents to the accompanying writ petition. On the ground that for granting for the reliefs as sought for in the writ petition cannot be granted without in their absence. This court have duly heard the learned counsels for the parties and is of the opinion that the said Boroland Territorial Council represented by the Principal Secretary BTC Pokrajar, number 2, the Director of Education BTC Pokrajar BTAD Assam, and number 3, the Deputy Inspector of Schools Bheragaon, Subdivision Bheragaon, PO Bheragaon under PS Tongla in the district of Udalguri are required to be implemented in the accompanying petition. Accordingly, the said accordingly, the said number 1, number 2, and number 3 are implemented as the respondent number 4, 5, and 6 to the accompanying petition. The petitioner is directed to file a file a memo of parties before the registry of this court by 14/11/2023, and on the basis of the instant order as well as the memo of parties so filed, the respondent the registry is directed to make necessary correction in the cause title of the accompanying petition, as well as also update the same in the CIS. With the above, the instant IA stands disposed. Yes, now what is this?
Yes, my lord, the issue is very small, my lord.
Will issue
That,
notice?
My lord, 99 he was appointed. After that, my lord, they were completed. They have the primary teacher, my lord. He has completed the my lord training also. Thereafter, my lord, in the year, my lord, 2012, that bulk termination order was there, and he found 200 days, my lord, 33, 285 teachers were terminated. Page 33. Right.
You are retired?
Not, then, my lord, my service was also terminated. Then they approached this court, and this court, my lord, in his case, 2019, my lord, that is, my lord, at page 39, was petition number 3, it was reinstated. Order is at my lord, page 41, 8/11/2019. But he was reinstated instead of my lord in a reasonable time. His service was reinstated in the year 2022 only, page 46. Whereas other petitioners were reinstated in 2019 only.
Now, what do you want?
Yes, my lord, because other petitioners, they have been reinstated in the year 2019, March 2019. And my lord, other petitioners also, but my service was reinstated in 2022. After my lord, almost 2 years. April 2002, page 46.
Intaz Ali.
Yes.
You were reinstated on?
For 1st of April 22. Order is of 19, my lord, 2019. And other colleagues, my lord, they were reinstated in 2019. So his limited prayer is my lord, continuation service for the fault committed by the respondent. He should be given the service benefit of 19.
Madam, there is a big problem which is happening here. Yes, Mr. P.N. Sharma. What has happened here? What have you done? He was to be reinstated as per the earlier one. What you have done out here is you have not reinstated. You have given him an appointment as those illegal appointees, not illegal, the irregular appointees. Remember?
Lord.
I think that is the resolution which was adopted
with prospective effect.
Have you challenged this, madam?
I have not challenged.
Without challenging it, you see, your appointment should have been made in this manner, which is there at page 45. Your appointment,
yes, ma'am,
reinstatement should be in this manner.
in this
No,
manner.
what they have
Yes,
done
ma'am.
is,
Language
they
and
have
everything, yes,
reinstated
ma'am.
you
Yes, ma'am.
as an illegal teacher, but receiving salary. Isn't that?
No,
Is it the type of
I
order
want
which is
similar
being passed?
benefit. That's why I have not challenged the appointment order.
Huh?
Because if I challenge my lord, that should be set aside or quashed. Then my lord, I'll be difficult.
No,
So
if
I
you
want
accept it, there is a big
similar
problem out there.
benefit as the other colleagues. That's why I have not challenged.
The appointment letter has been issued by the Director of Education,
They have to
PTC,
modify the
Lordship,
appointment.
Kobraga. This appointment is of fact the petition.
He has prayed for a direction for similar benefit along with his colleague.
No, here, if you don't challenge it, you won't get the pension. Because your pension dates back to long time back.
Yes. If I challenge it, my lord, that will be set aside and first.
No, no, no. You have to ask for a
Modified.
similar type of
Modification
appointment.
of the order.
The appointment is issued in concurrence with the issues department so and so. One is accommodated as a teacher purely on personal basis. This is actually what has happened, if I remember correctly. There was a inquiry proceedings carried out.
Yes.
As regards illegal appointments.
Screening committee.
This screening committee, there were a lot of people who were, some people were found to be properly appointed. Second people, there were people who were found to be properly appointed but not receiving salary. But there were some people who were, but not doing any job. But there were some people who were found that till a particular period of time, they have received the salary and thereafter not, till 2012 or something to that effect, if I remember.
2007
The
Inspector
condition
Mohammed.
was whether whoever received the salary up to 2006, they have been, my lord, allowed.
No,
So
no,
I
I'm
also
telling you,
get
no, no,
salary
you
2006
should,
before terminating me.
your
In
name
the
is
order,
this
it
fellow,
will be reflected. The
Imtaz Ali, na?
High Court order, it will be
Imtaz
reflected, my lord. So Lordship may kindly see if I find here the High Court order.
Mr. Sharma, I must have passed this type of order somewhere. Was this as regards not there? There were some people who were, I think that was an order passed by Justice Rishikesh Roy at that point. Anyway, but madam, you will be in difficulty. What you are asking for?
Says, my lord, allowed thereafter a whole lot, because other group cases I have done. Here, my lord, in the single means, I have received one or two more order. Otherwise, my lord, most of the orders, my lord, the single means is not allowed. Then they appeal, my lord, file writ appeal. In the appellate court, my lord, that a policy decision was directed to be made and regularize this discharge, service of this discharge. This person also same in the same category. And my lord, if your lordship kindly go through the order of this court, my lord, page 41.
But Lordship, if the petitioner accept this and join, then what?
Finish. Madam,
That-
your case will be finished if you accept
sure.
this in this manner. You should be asking for similar orders like for page 44.
Yes, ma'am. Page 44. That's what I am
You
asking,
should be getting this because once you get this,
Yes, ma'am.
then you will get as per the new pension scheme, old pension scheme, because you were appointed then.
99.
Yes. Otherwise, you are in trouble. I'm
Then,
telling
ma'am,
you.
I will depart, I may be allowed to withdraw file petition in that case.
Because
my
you
lord,
can't
I
amend
have
it.
asked for amend. I
You
have
can't
asked for the
amend
similar
this.
relief. So, my lord, agree appointment, other thing, that's everything similar. to
What
this
they have
person.
made you
Yes,
by giving this appointment,
yes,
they have rendered your status as an excess teacher,
excess.
which you are not. You are in trouble. You have to challenge it, challenge that without prejudice.
Yes. No, I may be allowed to withdraw my lord file petition.
The learned
Can
counsel
depart.
appearing on behalf of the petitioner submits that there are certain formal defects in the instant writ petition. And certain additional pleadings would be required, for which she would like to withdraw the instant writ petition with a liberty to refile by removing those formal defects and also making additional pleadings. She further submits that the withdrawal of the instant writ petition should not prejudice the rights of the petitioner. Taking into account the above submission, the instant writ petition therefore stands closed on withdrawal this court further grants the liberty to the petitioner to file a fresh
All that defects are 2000.
Yes. Home department is there. Yes. Provision. Book one. There are 4 books. 1, 2, 4, 5. Book one. Section 51 registers books to be kept in several offices. Book 1 Register of non-testamentary document relating to immovable property. 51. Book 1 Register of non-testamentary documents relating to immovable property. And section 2 in book 1 shall be entered or filled all the documents or memorandum registered under section so and so which relate to immovable property and are not with. Indexes to be made by the registry and contents.
certified copy provision is at page section 57. Yes. Right. Those documents are not available with us. By name, because these numbers are not there. They have to check one by one by name. No, that's 763. That is a little bit difficult, but as per our instruction, it was submitted, but not, I don't. They can verify the by name, by the name of the vendor or the purchaser. That is the issue. NOC was not there, therefore the whole issue came up. Six one check it. Five two. But it is not possible.
Seventeen and 18.
Obliged.
Nineteen.
Your Lordship, against the order passed by the Assam Board of Revenue, my lord. My lord, in this case, my lord, the learned head appear for the respondent, my lord, is a bereaved man, my lord, Dilip Chudhuri, and Akhia Chudhuri was, Arifa Chudhuri was there, my lord. So I pointed out if Lordship may, my lord, the impugn order, my lord, against the, my lord, mutation. Yes, my lord. The mutation was challenged, my lord. And subsequently, my lord, the mutation of both the person was cancelled by the impugn order. That earlier, my lord, the petitioner's father purchased a plot of land by unregistered sale deed, and subsequently, they between their family there is a partition, and after 46 years, my lord, then the petitioner's father's brother's son get their name mutation, and that was challenged because that was not the inherited property, that was self-acquired property of father. And they sought 1/4 as they are possessing. No. But that long possession, my lord, that because it's a yes. Mutation is there. Mutation, my lord. The mutation is there for a collection of revenue, my lord. Or possessor. Comma, there after comma is the word possession is there, my lord. Now land belongs to the person from whom land was purchased, my lord. He is not objecting. The purchase, my lord, on that time, my lord, would have unregistered sale date, my lord. Maybe taken up, my lord, maybe taken up any other date, my lord, that my friend is also not, my lord. My lord, that I'll become ready, my lord, on that point, my lord, because, my lord, he is also said, my lord. That's why, my lord, I was not ready on that point, my lord. I'll become ready on that next, any other date. My lord, that I was requested not to take up because made prayer before because I was requested that time, my lord.
Yes, for last or to continue, Lordship, the process is going on in the title suit. The title suit, Lordship, pending. Yes, title is given. But question is, Lordship, here, Honorable High Court also passed several orders. 4 orders I have. There is so many directions to the Deputy Commissioner and Circle for hand over the position and everything. That instruction has been received by my friend. Still 5 cities of property, Lordship. I have received instruction. Those are names recorded and some property handed over, only 2 property, but in some property, though the name are recorded, but not position handover. And most of the property from schedule 1 to 5 is pending. I have received all record. Yes, 2 property mutation. Yes, some property done. Some of the property mutation has been done. Here is the record I have received. Property. because Lordship, the honorable, this honorable court also earlier passed some order. Lordship is going on from 1976. The, the main title to it from 19. Yes, Lordship. Little Lordship may direct a specific time given and the deputy commissioner and circle of that they are not helping and not cooperating the process. The execution process. Although the whole authority is the government, Lordship, it is not private party. The authority is the government. The opposite party is government. They file a appeal also early. That was dismissed. The deputy commissioner is the in some order, Lordship, the Honorable High Court. Fifteen of the 2005.
Your Lordship, this matters related to as per the office memorandum issued by the UGC, there was a direction that if these persons who are working as a lecturer or assistant lecturer, they'll be given 3 increments or 4 increments as per the cutoff date within the service period if they get the UGC. So accordingly, you have PhD. I'm sorry. Accordingly, you have obtained the PhD degree during the service period within that cutoff date, and accordingly 3 increments were given to us. Thereafter, without any notice, without any justification, they have withdrawn it and they have started deducting that. So we have, yes, sir. Deeply obliged, sir. My lord, your lordship kindly see the last order dated 21/8/2056. Not. Total land is 5 bigger, 5 sir. But 50 bigger. Out of 15, 5 bigger, but a 10 is mine. Only one. Total 5 bigger. 5 bigger, 2 cutter 10 is mine. it is a construction has been started. There's the interim order, my lord. It's very clear that there shall be no any further construction on the land of the petitioner till the next. Up.
35.
Yes. The matter is not the immediate salary. Non-payment of immediate salary. Yes.
That part.
Yes, ma'am. Yes. But we thought it as per it, as per your lordship. But my lord, can it come on 23rd, man? 23rd. 23rd of the third. 23rd. Blood.
Take.
Better part is non-payment of various salary matter, test payment of sanction, test 21 matter. Non-payment of various salary matter, test 21 matter. They already sanctioned matter in the year 2019 matter. 21. 21. No. No, no.
Yes, sir. It would be the method. Director equity method. Convenience equity. No, my lord. My lord. Lovely.
Malad, in this case, malad, last kindly perusal last order, malad, direction was long order. My land. Pension, my lord. Family pension, but I have not received the family pension because my lord, 68, my lord, expired on 5683, sorry, 83. Applied, my lord, later on, my lord, later on. Communications, my lord, as it is seen, my lord, from the communication letter, my lord. Communication letter, my lord, representation, etc., my lord. 81 process was started from the year 1981. Application. Yes, my lord. Yes, my lord. 83. Petitioner also prayed for my lord for his my lord, service, my lord, regulation of the service, etc., my lord. Subsequently, my lord, some papers were submitted, my lord, and here, my lord, I have annex here, annex RK, page 29 is the first application, my lord, from the year 2002. Avail of family pension, my lord. Annex RK, page 29.
Number 8. Oh, Headmaster Vivekananda Amit. $21. Yes. Hmm. That's it. Yes, then my lord, it will be my lord. So I have here my lord incorporated is my lord. That that's it. Family pension here my lord, I have annexer K. Present 2 by representation submitted 710. But here as it is in my lord, yeah, subsequently collected, but a representation the UDR application possibly submitted here. Kindly peruse annexer K, page 29. Avail of family pension. Died in service, my lord. Yes, because earlier occasion, my lord, there was a question from the honorable court, my lord, about his age, my lord. Right? It be possibly in the service book, my lord. It will be in the service book. In the letter, it is evident, my lord. Letter issued by the inspector of the school. Wrote to the my lord, the director of pension, my lord. Service book, pension paper, photo. In this way, my lord, kept on the record in her file, my lord. I have the originals also, my lord. All the papers are here in very.
So the instructions in the matter. But Mr. Das, there's something fishy in your matter. Something wrong.
She could not able to.
Something is wrong.
But she could not be able to collect properly manage her.
As I am not taking up that usual bench, that man's bench is a usual, and I am not going in further in. But there is something wrong in that matter.
I will also check.
Because the person died, you don't know when, what is his age. And if he has died then, that is 40 years. When the writ petition was filed, then your petitioner became a widow at the age of 20. Think about it.
I'll take it.
Person died in the year 81, you get it registered in 2006. Anyway. Yes.
Matter pertains to my lord, non-payment of pro rata pension.
Non-payment.
Pro rata pension.
Pro rata pension.
Herein, my lord, it have issued a letter that I am entitled for pro rata pension. But no affidavit has been filed in this matter.
Yes, why haven't you filed affidavit? Long time old. Okay, Mr. D. Upaman appearing on behalf of the Health Higher Education Department submits that they have received some report that the Director of Higher Education has received some report, and on the basis of them, the said report is being the necessary papers are in the process of being placed before the Office of the Accountant General. Mr. R.K. Talukdar, appearing on behalf of the Accountant General, submits that the affidavit is ready and would be filed by next week. This is the matter again on 22nd of November 2023. On the next day, the Learned Council, appearing on behalf of the Higher Education as well as the Accountant General, shall obtain the necessary instructions as to when the petitioner, as to when, why, as to the entitlement of the petitioner.
Matter pertains to pension and other pensionary benefits.
Pension and other pensionary benefits. You have not received. Work charge.
Work charge.
Then?
Kindly come to order dated 4 August 2024. 4/8/2024.
4th August. Yeah.
Standing Council of the Education Department has submitted that the pension proposal has been checked the Finance Department.
This is the case for regularization of his service before the Finance Department, whereby the filing number is file an application.
Notice was issued long back.
You have retired.
Retired.
And you are not confirmed.
What happened? I was appointed.
You are not regularized.
I was appointed on 21/5/1991
as
works section assistant.
Then
subsequently terminated by the Principal Secretary Karbi Anglong Autonomous Council on 24/9/1991. Terminated. 24/9.
Okay.
1991. Subsequently, I have approached this honorable court by filing a civil rule. That is civil rule number 4919 of 1991. And this honorable court issued a mandamus lordship on 29 January 1993, directing my regularization. That order has attained final lordship, since respondent and authorities have not challenged it.
Then but were you regularized thereafter?
As per order of this honorable court, subsequently I was re-engaged on 27/7/1993. But that appointment order was not in consonance with the order of this honorable court.
Then?
And I was allowed to continue in my service
as
workshop section assistant.
Okay. Then?
And retired on 30 June 2021. And subsequently
30 June 2020. Yes, then?
Then executive engineer asked me to submit my pensionary documents before him for onward submission to the chief engineer. And accordingly, I submitted. While the matter reached in the office of the chief engineer issued the impugned letter, Lordship.
Which one?
Page 38, Lordship, and X-ray.
38. Tell me. I am to return here. Along with the particulars in the page to the return. Yes, then
Lordship, challenging this order, Lordship, I am before your Lordship. Because the order passed by your Lordship in 1993 has attained finality, Lordship, and the respondent authority now cannot take a U-turn, Lordship. An Honorable Apex Court in a recent case, Lordship, in the Nilima Srivastava, Lordship, kindly annexure 9, page 39, Lordship. Honorable Apex Court has held that the order which has attained finality cannot be hit by the dicta of the Uma Devi, Lordship.
Cannot be?
Hit by the dicta of Uma Devi. Order which have attained finality cannot be reopened, Lordship.
To me? Where?
Kindly come to 50 page 51, Lordship, para 29. The constitution-based bench has nowhere directed that service matters that stand concluded inter partes ought to be reopened.
Yes. So you are challenging this and government has not filed an affidavit.
But I am for KAC, Lordship.
KC, okay, but who is the main person to file? Finance.
It will be the Karbi Anglong authority. They are the one who have engaged him. Thereafter, according to them, my lord, they have regularized him. So this
They have regularized him.
No, some document certificate has been annexed. Lordship may kindly turn to page 35.
Hmm.
This is a certificate, not an order of regularization. It says, my lord, on 4/5/2019, the services was regularized. But that order perhaps is not part of the record. And this is a certificate. And there is no date also. So this to this where
No, it's okay, but once you regularize, are you not going to take into account his previous
past services?
past service?
So this
More
is
particularly that judgment I put of Justice Emartha, wherein it has been held that once he's regularized, the early so much of the earlier service is required to be taken
for the
for
purpose of pension.
only for the purpose of the
Computation,
pension.
yes. Pensionable service, my lord.
Now, if you have regularized him,
So there is no such order when I am saying, my lord, there is only a certificate to the effect that, my lord, he was regularized. But that document is not on the record. At page 35. This is a certificate issued by the executive engineer.
Lordship, in terms of the division-based judgment of this honorable court, in the case of Upendas.
Upendas is not for regularization. Upendas is a case for giving the minimum of the scale of pay.
In fact, regularization prayer was, my lord, turned down by that.
Yes, done. So it couldn't have been.
So we will grant us sometime, my lord, we will file one affidavit. Finance has been implemented recently.
Administrative department, that is irrigation, has already sent a proposal to the finance department.
If anything can be placed, my lord, I can have the specific instruction. If any
As per order dated 4/8/2023.
No, are you then, if you have retired, that 4/8/2020 or 22 and 22, 23 is an order by which you are going for again regularization. See the order, what has been passed. 4/8/2023 says, yes, 4/8/2000. During the deliberation of the matter, Ms. Neo, Learned Standing Council Irrigation, placed before this court that the authorities in the irrigation of the state have placed the case of the petitioner for regularization of his service before the finance department of the state by e-filing number 268-4040. The petitioner shall file an appropriate application for implement of the finance department as well as the treasury officer.
Accordingly, it was filed for
So, this is the regularization process has gone after your retirement. It can't be, you can't be regularized after you retired.
There is an order in that regard, my lord, of my lord Justice then retired I.A. Ansari, where, my lord, there was a order for regularization post retirement, 1-day regularization. At that time, there was such order. It was reviewed and honorable court said that when a particular employee could not be regularized during his service tenure, he cannot be regularized after his superannuation.
That too, obviously,
Yes,
you don't
in fact, it was
require,
placed
I also know.
Yes.
Yes, then
That proposal, otherwise, even if they submit, it will be an honest matter.
you file your affidavits.
My lord.
List this matter again on 11th of December 2023. The irrigation department as well as the finance department shall file the affidavit in the matter by 6th of December 2023. But that judgment of Justice Krishna Murari, which is there, which he has enclosed, is very relevant. Means once there is a judgment which has been passed directing you for regularization, then you can't, the matter has ended between both of you. So
But,
you
my lord,
can't.
that order says that, my lord, the authorities in the Karmiang law, they will formulate a policy for regularizing the petitioner. Not that, my lord, there is a direct mandamus, my lord, for regularization. To frame out work out a policy.
That mandamus was issued way back in 1993.
Yes, 1993. It says, my
But
lord.
only for framing a policy.
Yes.
For regulation.
Regulation. And I was reappointed, but not in consonance with the order.
Because at that point of time, 226 jurisdiction was there. It was only after Uma Devi's jurisdiction is no longer.
Sure.
But that judgment of Justice Krishna Murari says that yes, if prior to Uma Devi there was any directions, you can't say that I am not going to comply with it.
Sure.
Next.
4041.
This may take 41, my lord. I can know 40 is the sufficient allowance, and 41 is the dismissal order, my lord. This
40, 41, no. This is, I think, 42 Niki.
40, 41. 40, 41.
Which one is 40, 41? Yes.
My lord.
Let's say in 40, we are going to
What is this matter about?
Dismissal from service because after long service he was suspended, my lord. Subsistence allowance was not, my lord, not given, but this honorable court directed to pay the subsistence allowance, my lord.
Lordship.
After paying direction, initially DP was initiated, my lord. Then after retirement, he was dismissed from service, my lord.
No. What are you challenging in both the petitions?
First, my lord, subsistence allowance. Next, first 40, petition 40. 41.
No. 1658, what are you challenging?
1658 for necessary direction to pay the subsistence allowance, my.
Read in the nature to refix the pay scale of the petitioner.
My lord, earlier my lord.
Disburse and release the monthly salary with effect from so and so to so and so.
My lord. My lord.
Then this is the prayer.
My lord, there is a specific letter, my lord, by the director elementary education, my lord.
You are into 1658?
Yes, my lord.
Okay, what is your, you are asking for refixing the pay scale and also for disbursing and releasing for last 16 years.
My lord, my lord.
Why?
My lord, page 97, my lord, and answer 31, my lord, 1658.
97. Yes.
Director, with reference to the subject, my lord, director letter, with reference to, I would like to.
Oh, I remember this case.
Yes, my lord. Yes, my lord. My lord.
Then he was, I had given certain directions.
Yes, my lord.
Did you get the payment?
No, my lord.
Oh, they refused it.
Yes, my lord.
For non-furnishing of the non-engagement certificate, lordship.
Oh, yes. Now, I asked you to submit the.
I have submitted my.
There was a direction for payment of provisional pension. But for non-furnishing of the non-engagement certificate, the provisional pension could not be issued.
No, he has terminated. But did you?
Yes, my lord.
Then what happened?
Then also not.
Now
only
that order has been challenged in this new 4026 of 23, item number 41.
41, man.
So we are going to file our affidavit in item number 41.
Because this honorable direct to pay the subsidies allowance, my lord. On that reason, my lord, they dismiss the petition upon.
No, it's okay. Petitioner dismisses another petition. But here is a case where they say that we are not paying him because of the non-furnishing of the non-engaged
Yes, I have submitted, my lord.
Then also they have
Then
not.
also not.
I now remember that matter. Hello. You have filed your affidavit?
No, lordship. In 4026, we are going to file. We will file.
1658, you have filed.
Earlier, we had filed, lordship, but subsequent development, lordship. Now
4026, you have now.
4026, you need to file.
Okay. The learned counsel appearing on behalf of the elementary
lordship.
Education Department 6 to file the affidavit in WPC number 4026 of 2023. To list the matter again on 18th of December 2023. The affidavit be filed by 12th of December 2023. The petitioner, if so advised, would be at liberty to file the reply thereafter.
42.
Non-payment of family pension.
Why you have not got the family pension?
Lordship, here the Lordship petitioner stopped, Lordship, here the petitioner retired in the year 22/3/2005, Lordship, and he filed this writ petition in April 2022, Lordship. So he did not go to the office, Lordship, and Lordship, we have filed our affidavit. There is
No. He retired on
22/3/2005.
your husband.
Husband. And Lordship, husband died after institution of this instant writ petition. Subsequent,
During the
How did you get the? How will you get a family pension?
already petitioner has been substituted.
Huh?
Already
his wife has been substituted.
Wife has been substituted.
But the initial payer for
Now you are asking for family pension.
Family pension.
He have amended the petition.
No, Lord.
Still, there the problem arises.
Lordship, kindly pay the last order.
And your Lordship,
27/6/2023.
No, this is okay, but let this remain. But I think you need to file a separate one.
for family.
But already substitution petition has been filed.
Your right to family pension will arise only after the death. But that your petition was filed prior to the death. So your right to family pension was not there then.
I have already filed additional affidavit. Lord.
Mr. Counsel, kindly understand, by way of an additional affidavit, you can't have a substantive right. So you need to file another petition asking for a family pension. In this petition, how can you ask for the family pension? Tell me, have you approached them for the family pension?
My lord.
Yes, what happened?
Lordship, there is no any record of the writ petitioner working, Lordship. And Lordship, now we have asked for some detail to the Accountant General.
You have filed the affidavit
Yes.
and there is no record of the writ petitioner working.
And Lordship, we have requested to the Accountant General, Lordship, 5th of September, whether there is any record thereof.
Lordship, just now I have got it later, but next week not filed. Okay.
Mr. R.K. Talukdar appearing on behalf of the respondent, number 5, submits that he would obtain the necessary instructions in the matter in view of the specific stand taken by the Director of Higher Education.
No, Lordship, it is the Director of Health Services, Lordship.
In view of the specific stand taken by the Health and Family Welfare Department, that the petitioner, that there are no records, no service records, no records pertaining to the service of the husband of the petitioner. List the matter again on 22nd of November 2023.
All right.
Highly obliged.
43. Yes.
Also, my telephone instruction is that the matter is under process at the director level, Lordship. Once the process is over, the matter will be furnished to the director of pension, Lordship.
What is the matter? I don't know anything about this.
The petitioner retired on 31st.
What are you asking for? Setting aside and quashing the impugned letter dated 22/12/2009. 19. What is that?
The Lordship, the Director of Elementary Education
Regarding pensionary benefit in respect of so and so. Oh, you will get from stipend.
Yes.
Matter is there. What is there?
Again, reappoint. Yes, Lordship. That is the matter is under process, Lordship, and then it will be furnished. Initially appointed on 8/4/99 and again reappointed on 17/6/2004, Lordship.
No, you were appointed on 18/6/2004.
Yes. Initially
18/6.
appointed 8/4/99.
No. 8/4/99 for appointment on stipendary basis on so and so. In view of the WT message, the said appointment was suspended by so and so. Again, he was reappointed
Yes, sir.
by letter with fixed stipend of 1800, and he joined on 18/6/2004 as per the year. So it will be from 18/6/2004. You will be getting as per this then.
Lordship, that is why there were certain requirements from the petitioners and they have furnished, petitioner has furnished. Now the process is, the matter is under process at the director level, Lordship. Once that process is completed, it will be furnished to the Department of Pension.
So what should we do?
So the matter, Lordship will fix the matter after 4 weeks. By the time perhaps the matter will be.
4 weeks. The learned counsel appearing on behalf, Mr. P. N. Sharma, the learned counsel appearing on behalf of the elementary elementary education department submits that the petitioner that in view of the department's present stand that the petitioner would be entitled to the pension on the basis of from the date from 18/6/2004, that is the date on which he was appointed on stipend. The necessary papers are in the process of being sent to the accountant general so that the petitioner's pensionary dues could be duly pensionary dues could be duly so that the petitioner's entitlement could be duly disbursed. So taking into account the above, this court fixes the matter again on 3rd of January 2024. In the meantime, on which date the learned counsel appearing on behalf of the elementary education department shall duly apprise the present status of the petitioner's entitlement.
44.
The petitioner is agreed by a transfer order. Transfer order.
Then you got to stay. You're opposing.
Yes, Lordship, because he is serving in that place more than 16 years, Lordship, and only ground he has stated that his father and mother is ill, but his office is only 120 to 130
Minutes.
Lordship.
Minutes, kilometers, miles, which one?
Minutes.
Minutes. 120. Okay.
God.
Yes, you have been transferred from where to where?
From Disney Revenue Circle under Chirang district
To
Boroma Revenue Circle under Baskar.
Shirang and Baksa. Okay.
You want to say is your home district, Lord. It's home place, Lord.
You have been there for 16 years.
Yes.
Then you have a right. Permanent heritable right.
No.
Then what is this? 16 years you can be there.
Persons
What is
are-
your ground of challenge?
Persons are working there since 31 years. And
So what?
there.
They are trying to mend itself.
We are-
Does it mean that you are going to allow it there?
Though I was working in for 16 years in that Revenue Circle only, I was allotted different.
You have been working out there from initiation from your job when you started.
No,
2007. From 2007.
Because you are 44 years. Meaning thereby 16 years will be around how much? 26.
He was initially appointed at Tinsukia and his own request transferred to that place, Lordship, his own district, Bongaigaon. And
Is his post not transferable?
transferable, Lordship. Transferable.
There may show a judgment.
No judgment. Judgments are for division bench, not for me.
Actually, in this matter,
Not necessary. What is the allegation of malafide?
allegation of I have not alleged any malfeasance.
Then what is there?
I have only pleaded that my parents are with me. They are 90 years old. Old. I have to look after them. It is not possible for me to travel every day for 2 hours.
Don't travel. Go to Baksa.
Yeah, well, I have to bring my parents.
Take them along. They will also love the air out there in Baksa.
That may be a difficult
Don't
position.
you have the quarter? Is he staying in the quarter?
No.
In his own
There is no provision for quarter.
What is this job?
Mondal.
Mondal.
Record.
And who is paying for respond number 7? Yes, what do you have to say?
Same. He's serving here for 15 years, 16 years.
And you? You want to be at Baksa?
You want to get
You want to go to
Disney.
Sirang? No, these are cases where you go there, you may represent out there. That is it. Nothing more than that.
Already he has
Already,
submitted a representation
Huh?
and already he has submitted a representation and a speaking order has been passed in this case. It is a ground number for his silence lordship, page 44, annexure 13. His
Yes.
only ground is his father and mother is ill and he can look after because only 1.5 hour required lordship.
On 26 September 2020, the improved order was issued. I filed an representation. Thereafter, I approached this honorable court.
Annexure 13 lordship, this is the speaking order. Yes, 44. Last portion, it is stated where transfer posting of LR staff is regular exercise and as the incumbent has already passed in more than 15 years in the same revenue circle in the greater interest of public, the transfer order dated so and so.
Yes. What is this judgment of our coordinate bench? 2013 5 SCC that Mondols should not be transferred except on exceptional circumstances.
It is earlier occasion lordship. Now Assam government has already issued one notification. I think lordship. The Mondols are also transferable. Lordship.
Where is it?
There is no notification. Some communication is going on. But earlier, my lord, it was my lord that district was election was made for the appointment of the Mondol. Now, my lord, it was my lord the connotator state-wise. Everywhere they can apply and they can my lord put that and.
And lordship, it is transfer subject to PTC. Lordship already she has received one instruction. Lordship, it is with now PTC area. Lordship, PTC can.
Though they are posted at the same place for 16 years, but different time to time different lots are allocated. There are many lots in the revenue circle.
Then no, show me that you have a right to remain there.
My right to I cannot show any right. It's admitted question.
Why should this court interfere under 226?
May I show?
Because transfer is an administrative exigency. They may do so.
When the 26th September 2002 order was issued, I had filed a representation, and on the basis of that though it was not considered, therefore I approached this honorable court. That representation was disposed of on 29/9/2022, and they were directed to pass a speaking order. In the said that speaking order is at page 44. In that speaking order, they relied upon a report from the circle officer where it has been stated that report dated 1/10/22. That means after the judgment of.
What is it?
In that report, it is submitted that I have worked there for 15 years. So therefore, my service is transferred. That they transferred. So they have only stated that only. So, but there are other persons also in that revenue circle who are working for 31 years and 28 years and more. My submission is that only on the basis of plan from the service, it shall not be done. And in fact, I am relying upon on this judgment also that only on exceptional circumstances, Mondols can be done. In that district.
No, because at that point of time, how are Mondols appointed nowadays?
Nowadays, they are saying that on state selection, but at that time it was district selection.
So do you have a right still to continue as per that appointment?
But as per their submission, Lordship, till now there is no notification. There is that mandals are selected on state selection.
Now in PTAD area, there has been no mandal selected for the last 16 years.
I was not. I was working at that time, 2007. I was working in the Bongaigaon revenue circle, Bongaigaon area.
Bongaigaon is which district?
Bongaigaon district. In the Bongaigaon district under Disney. When the BTC was created, these villages where I was working, those fell under the BTC area. Therefore, I remained here.
Earlier, he was posted in Tinsukia Lordship initially.
That was initially in the year 2006.
He himself transferred
You go
from
to
Tinsukia.
Tinsukia. Yes.
Yes, Lordship.
You transfer him. Tinsukia. No, no. No. No, no, this court is not going to. Everybody has been transferred here. Leben Chandra Goyari from Jala Revenue Circle to Bizni. Kanjil Bosumotari from Boroma Revenue Circle to Jala. Abren Das, Bizni Revenue Circle to Boroma. Isre Musayari, Boroma to Bizni. And you got to stay. You remain there for 1 year. Yeah. You pay some cost to him for the expenses he had to incur. Yeah.
But this,
How much?
but this judgment, Lordship. But as per this judgment, Lordship,
Not judgment. That judgment is for the division bench.
only on exceptional circumstances.
Exceptional circumstances is there, but nowadays mandals are not appointed. Earlier, the thing was mandals used to be from other places. Mandals when other districts not permitted.
Not permitted.
But now it is
Now
permitted.
it is permitted.
That was the basis. The basis has eroded. The judgment is gone. I'll make it clarified why the judgment is not applicable. Because what circumstances you are saying that your parents are not well cannot be a good reason. If I hold it, it will be for everybody, it will be applicable. Then none of the people can be. My wife is not well, my son is not well, my parents are not well. Then
90 years old. I have annexed the Aadhaar card.
it is not yours, every case. Maybe.
For mandal, it is compulsory that it remain in that area.
Where?
No, no.
In the locality, they should remain.
So you remain in Baksa.
That is the difficult.
Why?
To leave his parents.
Then it should be remain in the Tinsukia. It should not be there that they given transfer to Tamala that Bongaigaon. Initial appointment was Tinsukia. It should be there. How can he be transferred to the Tinsukia to Bongaigaon? It's a problem.
Hmm?
It will create problem.
No. The instant writ petition has been filed by the petitioner challenging the order dated 26/9/2022, whereby the petitioner was transferred from Bizni Revenue Circle to Boroma Revenue Circle. And the respondent number 7 was transferred from Boroma Revenue Circle to Bizni Revenue Circle, along with 2 others. The facts involved in the instant case is that the petitioner was initially appointed as Lot Mandal in the year 2006 at Tinsukia, in the district of Tinsukia. Thereupon, the petitioner had, at his own request, thereupon the petitioner, on his request, was transferred to his home district, that is at Sirang. Sirang, na? Bongaigaon. In the year 2007 itself. Subsequent thereto, with the formation of the BTAD, the petitioner started performing, functioning as a Lot Mandal in the district of Sirang and had been functioning therein for the last 16 years. By the order dated 26/9/2022, which have been impugned in the instant proceedings, the petitioner has been transferred from the Sirang district to the Buxa district. That is, from Bizni Revenue Circle to Boroma Revenue Circle. The grievances of the petitioner are twofold. First, that in view of the order, in view of the judgment, first, that the judgment of the transfer of the petitioner who is working as a Lot Mandal was contrary to the settled principles of law as held in the case of Kamini Kumar Brahma and others versus State of Assam and others, reported in 2013 5 SCC 668, inasmuch as in the said judgment, the court and bench of this court had categorically held that unless exceptional circumstances exist, the Lot Mandals should not be transferred to another district. The second ground on which the petitioner have challenged the transfer order is that the petitioner's parents are 90 years old, and it would be difficult on the part of the petitioner to look after them if he is transferred to Buxa district. On the other hand, Ms. R.B. Bora, appearing on behalf of the BTC or BTAD? BTC, submits that the said judgment in the case of Kamini Kumar Brahma is not applicable to the instant case for two reasons. First, the judgment which was rendered in the case of Kamini Kumar Brahma was in the facts when was the judgment in the case of Kamini Kumar Brahma was rendered when persons from other districts could not participate in the selection of Lot Mandal in respect to a particular district, which however is not applicable. Secondly, the said judgment is not applicable in view of the fact that the petitioner himself was appointed at Tinsukia, and at his own request, he was transferred to Bongaigaon. And as such, the petitioner cannot claim the benefit on the basis of the said judgment. As regards the ground taken that the petitioner's parents are aged, it is the submission of the learned counsel appearing on behalf of the BTAD that the distance between the petitioner's present location, present posting, to the transferred location would require traveling up or around 1.5 hours to 2 hours. And as such, the ground on which the petitioner is seeking that he should not be transferred is totally misconceived. She further submits that the petitioner have been in the same post, in the same revenue circle for the last 16 years. And as such, on account of administrative exigency, the petitioner has been transferred. I've heard the learned counsels for the parties and have also perused the materials on record. I've also perused the judgment of the coordinate bench in the case of Kamini Kumar Brahma Supra. It is from a perusal of the said judgment. In the case of Kamini Kumar Brahma, it has been categorically mentioned the courted bench of the court had held from a perusal of the said judgment, and more particularly at paragraph number 29 and 30, it reveals that the courted bench of this court had duly taken note of the advertisement which did not stipulate that preference would be given to the local candidate of the district, or that once appointed a mandal would not be able to seek transfer to outside the district. It was also observed that the transfer and posting of the government servants is within the realm of the administration. This court therefore finds it relevant to quote paragraph number 29 and 30 of the said judgment. 29, 30, and 31 of the said judgment as hereindunder. From a perusal of the said judgment, it would be seen that the court and bench have duly held that on account of administrative exigencies, the state had the power to transfer a government servant in the exigency, administrative exigency. The state had the power to transfer a government servant. And it was only mentioned that inter-district transfer of a mondal cannot be resorted to in a routine manner. However, in the instant case, the petitioner, at his own volition, has sought for transfer from Tinsukia to his home district, and thereupon have been working in the same mandal, same revenue circle for the last 16 years. The transferring of the petitioner on the basis of by the impugned order cannot therefore be said to be in a routine manner, for which it is the opinion of this court that the order of transfer cannot be said to be contrary to the law laid down by the coordinate bench in the case of Kamini Kumar Brahma Supra. The second question which arises, second ground which has been alleged, is that the inconvenience which would be caused to the petitioner on account of the petitioner having aged parents. The said ground, though may require sympathetic consideration, but that cannot be a reason for exercising a jurisdiction under Article 2 to 6 of the Constitution. Inasmuch as exercise of jurisdiction under Article 2 to 6 of the Constitution in respect of transfer matters is very restricted. Under such circumstances, this court, therefore, is of the opinion that the impugned order does not require any interference under Article 2 to 6 of the Constitution. Accordingly, this court, therefore, finds no merit in the instant writ petition, for which the instant writ petition stands dismissed. The interim order passed earlier stands vacated. Be that as it may, this court, before concluding, finds it relevant also to observe that the petitioner, after acting upon the transfer order and joining the place of posting, would be at liberty to represent the respondent authorities for consideration, and the respondent authority, taking into account the exigency, will duly take note of such representation.
Give 45.
Yes, Mr. Solia.
My lord, the petitioner has not received his pension, although he has served more than
15/3/2021. Which one?
my lord.
15/3/2021 is that order. Which order you are challenging?
By that order, my lord, the petitioner has been asked to pay 35, sir.
Huh?
Page 35.
Page 35. With reference to it is to inform you that your leave account, per leave account, at
Of-
this
at-
point you have earned leave account at a credit or was exhausted on demand. That is the date you were released from
Released
the
from
to
Test
join the
University
post of
service,
the union.
join the post of
Finally released from test you may write to narrate to test for your pensionary benefits with pro rata and benefits to the length of the service rendered at the reserve will be transferred to narrate. Now you are challenging this.
I'm telling him because, my lord, firstly, the marriage to which the petitioner was to next job does not have the pensionary benefit.
Mr. Solia, we'll do one thing. We'll
Madam.
have it on, this is a pensionary, you are not getting your pensionary benefits.
No.
He is not entitled from us.
Okay.
He will entitle pro rata pension. We will send it to the nearest lawsuit, the nearest will defer.
Wait, Neris is the party?
Nearest is not a party here.
Why haven't they made
No,
that?
Neris, I'm not required to make Neris the party below because at the initial stage when I came to Tezpur University, I informed the authorities that I will take my pension from that university. And immediately when I resigned my service below because on resignation also one is entitled to pension.
It's
Mr.
a,
Solia.
it's a technical registration after the
No. At the end of the day, you want your pension. Isn't it?
Mal-
What is the problem in making Neris the party? You see, he's saying he's not going to pay, Neris is going to pay. Somebody has to pay.
For that, Milord, I want to say, so, Milord, here affidavit themselves stated that how the pension is to be paid. And they
We'll have it some other day.
Yes,
My lord,
Huh?
my lord.
Today is pretty late.
Lordship.
And I'm not a regular bench. Taking into account the pleadings are complete, list the matter again on 23rd of November 2023, on which date an attempt shall be made to dispose of the petition. We are fixing it for final disposal.
Lordship.
My lord.
You want the pension. But think about it to make Neris the party.
Nearest is necessary.
Then we can get hold of anybody, na?
Lordship.
And pass appropriate direction.
And nearest step no lordship pensionary benefit lordship. Nearest test CPF contribution.
For that
Oh.
reason, Milord, I wanted pension from 20%.
He is not
Okay.
entitled as
Neris doesn't have.
as because lordship his lien is permanently absorbed in that nearest.
No, no,
After
not-
10 I will place everything lordship.
Okay.
Everything I will place.
Yes. What are these?
It's a matter of non-payment of family pension, my lord.
Okay, we'll have it on some other day. You've got your instructions?
My lord, it's a similar matter which my lord had made an observation in the morning during the first half, wherein he is seeking family pension, whereas he has,
Item number 12 and 13.
whereas he was regularized in the year 2003, he died in 2006. He's claiming family pension. However, he's not meeting the minimum qualifying service period. So minimum to
But he
avail
died during service.
during service.
So then again, the same thing will apply.
Same issue.
When is
crops
that
up.
matter fixed?
My lord, that was fixed, I think, 14th of November.
No.
14th of December, sorry.
List these two matters along with Hey matter to Logot on 14/12.
Right.
8 December, my lord.
8th of this.
Oblige.
Yes, what is this?
Lord, in fact, the affidavit in reply has been filed by the petitioner.
Everything filed.
Yes,
What is the petitioner asking for?
my lord, he is aggrieved by the order of removal from the post of secretary of the cooperative society. I am representing respondent number 5.
Wait. Here. This is another case where by drawing reference to the resolution adopted in the executive meeting of the board of directors one day before the day on which the received the so-called notice Taking into account that the pleadings are complete, leaves the matter for admission on 13th of December.
Public.
May I please?
Mm.
Non-payment of area salary. Non-payment of area salary. For Dr. P.O. from Lordship 28/1/2005 to 28/2/2006 Lordship. And end Lordship 1/7/2007 to 28/2.
You got?
Lordship, we have sent the proposal, Lordship, uh, for sanctioning of the amount, my Lord.
This is another matter. 1610. Where is the 1610? Oh, yeah. In compliance with, along with area particulars, the additional and non-royal certificate submitted duly consistent. Okay, level. The instant writ petition has been filed by the petitioner claiming an amount of rupees seeking have filed by the petitioner seeking release of his area salary for the period from 28/1/2005 to 28/2/2006 and 1/7/2007 to 28/2/2008 along with interest. From the record today, Ms. D. Musari, the learned counsel appearing on behalf of the petitioner, respondent, Secondary Education Department, submitted that after making necessary verification, it has been found out that the petitioner is entitled to an amount of rupees 1,69,415. And in that regard, the Director of Secondary Education has written to the Secretary to the Government of Assam Department of School Education for providing necessary sanctions for an amount of for the said amount, so that the same could be released to the petitioner out of the budget provision of rupees 5 crores for the financial year 2003, 2023 and 24. In that regard, Ms. D. Musahari has also placed the instructions, placed the said communications, which is kept on record and marked with the letter X. Taking into account that this is the amount, taking into account that the said amount of rupees 1,69,415 has been duly admitted by the respondent authorities, and the only formality left is the sanctioning. This court disposes of the instant writ petition, directing the respondent authorities, more particularly the Director of Secondary Education, Assam, to directing the Secretary to the Government of Assam Department of School Education, as well as the Director of Secondary Education, Assam, to do the needful so that petitioner is released his area salary of an amount of rupees 1,69,415 within a period of 2 months from the date of service of a certified copy of the instant order to the respondent number. Where? Respondent number? Respondent number 3.
50.
Obligation.
With the above observations and directions, petition stands. Yes.
This is also related to pension, Your Lordship. By impugn order, I have been paid lesser provisional pension. My last pay I have drawn, Your Lordship, is a 1 lakh. Basic is 1,87,000.
You want the enhancement of provisional pension?
Yes, yes. And
you have filed the affidavit?
No, Lordship.
You are filing?
Instruction is awaited, Lordship. 2 weeks time maybe.
Okay, 2 weeks time is granted to the higher education?
Yes,
yes.
Higher Education Department to provide the instructions in the matter. To 2 weeks time is granted to Mr. D. Upamanu, the learned counsel appearing on behalf of the Higher Education Department, 6 for an accommodation to obtain the instructions in the matter. Accordingly, list the matter again on 8th of December 2023. In the meantime, the respondent, the counsel representing the Higher Education Department shall obtain the necessary instructions.
On the last occasion, your lordship, that a pendency nobody to consider the regular bench. That may also.
Order is there.
There.
Then you don't require again. Yes. Tell me.
The petitioner had two casual employees, pursuant to the judgment of when does the department has taken a decision to grant 15,900 to anybody who joins before 1/9/2005. Initially, our dates were wrongly sent. Later on, at page 29, Lordship would see. Page 29. Lordship.
Yes, Mr. Hendik, I fixed that matter na, today. When? That item? What was the item number?
My lord, item number was in the motion stage, my lord. Yes.
It was corrected. The date was corrected.
No. I'm asking that item number.
I'll just get it, my lord. Just give me a...
I have to case
11th of December.
What is the number of the petition?
6454 of 2020.
I list this matter on so and so 11th of December 2023. Along with
writ petition 6454 of 22.
Yes.
This matter is getting the pensionary benefit. Their benefit is some returnable date today, and the respondent directed to file a affidavit in last occasion report. They brought some facts given by the rep.
Not directed where allowed.
Yes, they prepare for the filing affidavit on basis of some document.
Lordship, these are the, I've got the instruction, Lordship, these are the illegal, irregular appointment at Damaji district.
Okay. So we'll have it on some other day.
Subsequently, they have been accommodated as tutor, and they have accepted and they have joined. They have accepted and joined. But unfortunately, they have retired in the meantime, in a span of 1.5 years or 2 years in between. They have accepted the appointment, they joined their respective schools.
Excess.
Subsequently, they retired. So they are not entitled. They have accepted the terms and conditions. To
file a short affidavit, I think.
Lordship.
Better off, na? So that he can file his reply.
Lord.
Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, submits that he has received the instruction and would like to file an affidavit in the matter. List the matter again on 6th of December 2023. The affidavit be filed by 29th of November.
55.
Yes.
Lordship. Lordship, the matter just temporary attachment matter.
Temporary?
A temporary attachment matter. That's page 41.
That disciplinary proceeding was
Going
on, Lordship. Is pending, Lordship. And Lordship, suspension was made, Lordship, that reinstatement, Lordship. Network transfer was made.
Due to malified intention.
No, Lordship. No, the case, Lordship, it was there, Lordship.
Temporary?
Temporary attachment, Lordship. From Director Museum to District Library, Dhubri, Lordship.
And then?
And
you removed him?
No, Lordship. Yes, my disciplinary proceeding is pending, Lordship.
Oh.
Disciplinary proceeding pending. That's why, Lordship.
And temporary attachment, there is no such post of.
No, Lordship. In the Ajay Chaudhary case, Lordship, it is there, Lordship. In Ajay Chaudhary case, Lordship, paragraph 14 is there, Lordship. Government may.
In which post he will join, my lord?
Government is free to transfer.
Oh, you have been suspended?
No, my lord.
No, it is reinstated. Subsequently, it is reinstated, Lord. BP is pending, Lord.
Hello. You got your instructions?
Lord.
You have one to file affidavit?
Lord.
Mr. So-and-so, the learned counsel appearing on behalf of the
respondent. Lord.
Respondent 6 for 2 weeks time for filing the affidavit.
In the meantime, I remember there is
interim production, my
No,
lord.
Lordship.
I'm under medical treatment, my lord.
No,
Bunch
Lordship,
of bunch of paper is there, my lord.
We
And I
It's a
have to-
temporary attachment, Lordship.
Please the matter again on 29th of
Lordship, bunch of my medical
No.
paper is there, my lord. I am undergoing
29th
medical
of November
treatment. Under
2023.
the-
Lordship, that's
Mr. Counsel, kindly appreciate. This court is not a regular, these matters. Now, if I was a regular, I would have then taken the responsibility of having it on next Tuesday and finishing it. But I am not in a position to do that.
on the
And
last
now at 5 o'clock, do you expect this court to do that?
on the
It would
last
not
occasion-
be proper.
on the last order, my lord, the honorable court the interim will be considered today, my lord.
no, Lordship. Instruction received,
There is a
Lordship.
11:10, my lord.
The instruction received, Lordship, that transfer was made only.
The prayer for interim shall be
Temporary
considered
attachment,
on
Lordship.
next returnable date. Okay, what is the interim you want?
Interim, my lord, till then, my lord,
Say the operation of the impugn order issued by OSD. What is that impugn order?
lordship, I'm suffering from medical treatment, my lord. And
Where is the interim order? 18.9.
Lord.
Pending departmental proceedings so and so who was placed under suspension is hereby reinstated and temporarily attached in the office of the district museum officer so and so in the same capacity of A with immediate effect. In this regard, the period of suspension by the order dated shall be treated as due. There is the order.
Lord.
You are challenging page 41.
Page 41, my
You want to stay?
Lord.
Okay, then you will be under suspension.
only temporary part I have to
No, you will be suspension.
only temporary. Only temporary.
You have been placed under suspension,
Suspension, Lord.
reinstated.
Reinstated, Lordship. Yes,
So
silence.
you want that you would want to remain under suspension?
Lordship.
I am only challenging the temporary attachment, my lord.
No, Lordship, the whole,
Lordship, kindly see, my lord.
whole impugn order
But,
silence, Lordship.
Now, has the memorandum of charge been given to you?
Lordship, I have already submitted all the documents from the focus also.
Have you filed your reply?
Lordship, and they have also given the report, my lord, the inquiry report. And on this report, I have filed all my representation, my lord, as per the direction of the director, my lord. Thereafter, time is pending, my lord. And on the direction of the director, my lord, I am the only the senior assistant, my lord. Nothing, my lord. And they have instructed me to draft the service rule, my lord. I drafted, my lord, and issuing authority to the director, my lord. And due to their fault, my lord, I am liable, my lord.
Lordship, in the interest of transparent.
Okay, I'll do one thing. Please, at the request of the learned counsel appearing on behalf of the petitioner who expresses urgency in the matter, list the matter again on 15th of November 2023. In the meantime, on the returnable date, or on the next date, the petitioner would be the interim order on the next date so fixed. The interim order shall be considered. The petitioner is further given the liberty to mention the matter for upgrade. Even admission. I mean, admission really.
My lord.
Yes, what did you get?
My lord,
See, I waited for you. You went for the tooth of your child.
my lord,
I said, don't worry, everything will be finished, then the matter will be taken.
my lord.
Now, what do you want to propose with this matter?
My lord, I got the instruction yesterday, my lord. Only thing is that they say that if the department will not proceed, they have nothing to, because there is an interim order whereby the honorable court has decided not to finalize.
What is your stand?
Then Lordship, I'm new to this department. I have to take instruction, Lord.
I asked you in the morning itself.
I want written instruction. I sought written instruction from them, Lord.
What do they say? Because there is a stay.
Stay, yes.
That tender has become useless now.
Yes.
You see, for 4 years,
4
or 5 years, nobody is going to give at the same rate.
Yes.
The rate at which you have sought for 5 years back,
Lordship.
why will a person now will be willing to?
Lordship.
Means, and your bid validity period, which was there, had also expired.
Yes, Lordship.
So, what remains in this petition? Nothing. We'll have it on Wednesday next.
I will,
You get your instructions in written.
my lordship.
Because I don't think you are also going to supply at 2,35,000 or 2 crores 35.
After awarding the, my lord, has to be supplied in 30 days.
This is what? No, that is right.
Yes.
As of now, it has become infructuous. I'm just keeping the baby out there. Today, somebody mentioned, I just asked them that only one instruction, whether they are ready. Okay, list the matter again on 15/11/2023, on which date Mr. P. Sharma, the learned counsel appearing on behalf of the Fishery Department, shall obtain the instruction as to whether the Fishery Department still proposes to go ahead with the said tender.
Obliged.